Okay, so it being 10 o'clock, I'm going to open the public hearing on House Bill 655. See, we have a bunch of people there. If, for those who want to speak but have not put in a pink card, please fill one out and pass it up. I'd like to recognize Representative Carol McGuire. Oh, you're here. I can pass it.
Quickly, Mr. Chairman, that we're out of pink cards at the moment,
Oh,
so.
are we? Thank you.
Yes.
Yeah,
Someone should run down.
Somebody's already working on it, but
I'll let you take over. So here's
Thank you, Peter.
the one on the back. She wants to speak last.
Good morning, Mr. Chair, members of the committee. I'm Carol McGuire, representing Merrimack District 27, which is Allenstown, Dunbarton, Epsom, and Hooksett. This bill is a recommendation of the Study Committee on OPLC operations, and it is essentially a recodification of the licensing laws to clarify who is responsible for what and how and what the relationships are. So the first part of the bill, starting on page 2, is an overview of the Office of Professional Licensure and Certification. It's got the list of boards, which is all of page 3 and all of page 2 and most of page 3. It's got the unclassified officer, the duties and responsibilities. On page 5, Roman 2, which starts on line 10, is actually a bit of a duplication of House Bill where's that? 445. So we will need to consider how to handle the duplication because it's not identical, but it's very close, including the $5 million cap on the fund. What else we got there? The next fund is the Impaired Professionals Fund, which covers the cost of treatment for doctors, dentists, pharmacists, and nurses that I'm sure of, and possibly others, that are impaired by drugs and or alcohol. And so those people pay for this and are assured to it. All right. And what else? Then there is the Rulemaking Authority, which includes a notice that any existing rule is still valid until it is revised or repealed, so that we don't have to worry about repealing all of our existing rules when the laws change. And then there are temporary licenses, license renewal procedures, complaints and investigations, more complaints, sanctions, licensing procedures, etc. And then there is the Oversight Committee, which was established by Senate Bill 330 last year, which is in effect. It has not been staffed yet. That is, nobody's been appointed to it that I know of. So that needs to be confirmed that that's correct. And then starting on page 13, there's a whole list of repeals, and both of sections and lineouts in continuing sections of law in order to coordinate with the first part of the bill. It starts with the Board of Accountancy and goes on down to, who's the last one? Reflexologists and physicians, etc. So the intent is to clarify that the OPLC takes care of administrative duties, and the boards are responsible for the items that need professional skill. Reviewing any license application that is not perfectly obviously suitable, including criminal records that are not perfect. discipline and sanctions responsibility of the boards. And what else? Continuing education, approving continuing education courses. Those are the responsibilities of the board, and the OPLC is in a support function to all of them. And I believe this bill is going to subcommittee on Friday. So if, I may not be able to answer your questions, but I'll try.
Thank you very much, Representative. Any questions? Yes, Representative Lakis.
So you mentioned that the disciplinary stuff belongs to the board, but to what extent is like organization and administrative support and all that being handled by OPLC?
It should mostly be handled by OPLC. So they would have the staff that produces the licenses, that produces the agendas for the board meetings,
Right.
that refers the questions, the complaints that look like they need to be resolved to the board.
Okay, follow up.
Follow up.
So basically, the board wouldn't have to, would just look at them, make decisions based on their professional experience, and then then it'd go back to OPLC for whatever.
That's the intent, except that in the case of discipline, the board is essentially the jury, and they determine whether discipline is required, and if so, what, if any, penalty should be applied. They have the choice of sanctions, yanking the license, additional training, fines. They have a full gamut of penalties as appropriate for the discipline.
Okay, thank you.
Anyone else? Thank you very much, Representative.
Okay, thank you.
Representative Will Infantine.
Morning. I'm gonna turn off my phone so no one calls me and interrupts us. Because I'm told you get a fine in this. Okay, I'm on mute. Good morning, folks. My name is Representative Will Infantine from Manchester. I'm an insurance agent by trade, but I'm also the vice chairman of the Electricians Board. And I've been serving for about, I think, 5 years on that board. I wrote on my pink card, I wasn't sure if I liked this bill or not. There's parts of it I do, there's parts of it I don't. Now, I did not attend some of the summer meetings, but I have read every single page of all the minutes that were produced from the subcommittee this summer. And I don't have a problem per se with the fact that the OPLC was this big animal that needed to be better organized, without question. The commissioner tells us that, well, there were different boards that don't meet. They don't show up. We can't get a quorum. They have their own different letterhead and all kinds of things were just going all over the place. So she's made Herculean efforts to try to organize things. But I'm very cautious and very concerned that some of the things may gone a little too far. And part of the reason is because there are so many of these different organizations within the OPLC. And not everyone has the same issues. You have a bunch of, from construction people to massage therapists to funeral directors, they don't all have the same things in common. They don't have all the same types of issues. I would rather see this broken down into 3 subsections within the OPLC. I'm not trying to create anything different, but the construction-related trades are one thing, the health and related trades are another, and then the professional related trades are another. And I think trying to put all these things into one, it really doesn't match. Now, there's something in here about fines. The Electricians Board has never had fines. When we have disciplinary issues, we bring someone in, and we have mechanisms allowing us to suspend their license, to make them go to additional education. We can ask them to have to present every month where their jobs are going to be so they can be inspected more often and make sure they're doing things. Now, that may be much different from a different organization that maybe is used to, or the only way to get people to pay attention is to give them a $3,000 fine. But I'm not sure it needs to be across the board. My biggest issue has to do with page 20 of the bill. If you see, that has to do with electricians. They've repealed a lot of our decision-making ability. Right now, people volunteer, like myself, to be in these boards. And as the chairman told me, you know, sometimes we are the electrical contractors' police. People get in trouble, they come to us, we adjudicate these things. And there seems to be a movement toward getting rid of having boards be in that position anymore. They want to have experts brought in. They want professionals to deal with investigating a situation and giving a fine or doing whatever, going through that whole hearings process when someone has done something wrong. Well, if that's the case, what are we here for? Why do I bother with my time? 10 months, 10 meetings a year. And if you take away all the board's authority, then why would people like me volunteer? Why bother? You're going to have people even wanting to go when the real meat and potatoes of what we're supposed to do as our peers through our trade, I can't really do anything. Something happened, and I don't know what it is, and no one will tell me, and I'm not a conspiracy theorist, but something happened where someone got in trouble or someone didn't do what they were supposed to do, because there's been a major change in the last year of what's gone on in the electricians board. We used to ask for a lawyer to come in if we had a situation. Now they're automatically there at every meeting. Now the OPLC wants to create a matrix of, if someone gets in trouble, what the fines can be and what the procedure is. Well, if you tell everybody out in the industry and everybody knows what the penalty will be for violating the rules, they'll make a business decision whether or not, oh, well, that's all that's going to happen to me? Okay. I guess that's a business decision. I'll take that $3,000 fine, or I'll take that fine that is in this matrix. And it's not always that simple. Nothing is ever easy. We had the hardest meeting we ever had yesterday with a convicted felon who created a heinous crime, and we had to make a decision whether or not they should get their license. That's not going to be in your matrix. I don't want to go into every detail on every single page here because I know there's going to be a subcommittee in 2 days. My opinion is there's been some major changes for the good at the OPLC. But you can't put everyone in the same category, and this bill kind of does that. And at the same time, on page 20, you take away all these rulemaking, disciplinary action, hearings, appeals, investigation authority that is in lines 13 through 21 that you want to appeal. Some of it's just gone a little too far for me as a member of the Electricians Board. So great job by the subcommittee, Members of Goli and everyone else that was on that. Great start. A lot of good things in here that clean things up. But one of the things I've learned here in my ninth term as a representative is to be cautious about going too far, because sometimes we do, and then we have to repeal it the following year. And I just want us to be very cautious with this.
Thank you, Representative. Will you take questions?
Yes, of course.
Any questions? Representative Schmidt?
Thank you very much, Mr. Chairman. And thank you for longtime colleague for being here today, because I think I'll winnow it right down to one question, because I think to the degree you can be here for the subcommittee on Friday, where we're going to take a lot of these individual details under the microscope, your expertise could be really helpful, and I'm wondering whether you're going to be available.
It was up in the air, but now since you asked, I will be there.
Thank you.
Any other questions? Representative Schuett.
Thank you, Mr. Chair. Good morning to one of my former chairs.
Good morning.
In relation to Representative Schmidt's question, do you think you will be able to come to our subcommittee meeting Friday morning?
Yes, I'll be there.
Thank you. I'll wait for my questions then.
Yeah, I understand there's a hearing. There's a lot here. it was daunting when I looked at 77 pages and started going through it, but a lot of it is obviously after the page 20, it's a lot of repeat. But it's amazing sometimes how one little change, and there'll be some people testifying after me, one little sentence or 2 or 3 little words that I didn't even think of reading it through the first time that have some major consequences. So unfortunately, it does have to be studied almost line by line.
Thank you very much,
Thank you.
Representative. Elizabeth Eaton, OPLC.
Good morning, honorable committee members. Thank you for hearing my testimony. My name is Elizabeth Eaton, and I am an attorney at OPLC, but I'm here on behalf of the Board of Psychologists today. So I'm taking off my OPLC hat and won't take questions regarding the agency, but I will be testifying on behalf of the board today. I have a letter that the board issued, and I'll be reading that. And I have Dr. Walrath with me here. He is also on the board of psychologists. So the letter states, and it's regarding sections applicable to the Board of Psychologists. The Board of Psychologists understands that an efficient consolidation of administration will be a positive direction for the department. Yet the board is very concerned that the statutory changes proposed in the new OPLC bill will greatly diminish the effectiveness of the board, the protection of the public, and fairness to the occupations of the psychologists it regulates. The board sees many problems with this bill and strongly urges the committee to retain the bill in committee to study the bill, so that many details that are harmful can be known and resolved before sending it to any further action in the House. Below are just some of the major areas of our grave concerns about the bill. We hope that the details of these and our other issues could be discussed in detail, along with our other professions, as your committee could keep and study the bill. While the board wishes to cooperate with consolidating administrative supports, it is seriously concerned about the eliminations in the bill that would seriously affect the well-being of patients and the due process of the board. So below, I'm going to elaborate on some of the issues that the board has. The bill eliminates an important protection to the individual's private medical records in the repeal of RSA 329B22(6). This important privacy protection safeguards the privacy of medical records in the process of investigations when the person complaining is not the patient and does not have the right to share the records. Another section, the bill repeals an important part of due process, eliminating the summary of findings from an investigation that currently is shared with the licensee before facing settlement, a step which gives the licensee a review of the facts that have been assembled against them. The bill repeals RSA 329B22(9), which provides this fair due process. The bill also repeals RSA 329B22(8) that requires the immediate notification of an allegation, sending the copy to the licensee. The board sees the value of informing the psychologist because it protects the public and brings immediate awareness to the doctor of the issues that offended the alleger, especially important in ongoing treatment. The bill also repeals RSA 329B22(10), which will lose the distinction between the status of an allegation versus a complaint, which is a very important safeguard of our board's statutes and process. Only after the board has determined that an allegation could violate practice laws, it is elevated to be a complaint, and then it is formally investigated. Under current law, the allegation, which is the first communication to the department, is completely confidential in all respects, being protected in statute from reporting by the licensee practicing their occupation of psychology. Once it becomes a complaint, if reportable in the doctor's professional accountability, it is reportable in the doctor's professional accountability to insurers, hospitals, and practice associations. Finally, the Board of Psychologists hopes to be helpful in the process of making the department streamlined, but also effective in protecting the public and in fairness to the individuals practicing their occupations. The board requests that you retain the bill in committee so that we and others can facilitate the reconciliation of these issues for better health boards, safer practice, and fairness to the occupations.
Thank you very much. Will you take questions?
I'll take some questions, and Dr. Walrath can also help me answer.
Great. Any questions? Representative Schmidt?
Thank you, Mr. Chairman. Well, as has already been alluded to, this bill is going to subcommittee where we can get into these details and try to work them out. So are you or any member of your group going to be able to be here to assist us in that task on Friday?
Personally, I'd have to look at my calendar as I'm representing other boards in front of committees. I would, if I can be there, I will.
I'll certainly make every effort to be there. Right now, I have some conflicts, but I think I can work those out.
Follow up. So I'm speaking now to the attorney. I didn't quite get your name. Apologize. But you've already gotten into some of the details of issues that you have a problem with. So the question is how we can, other than just striking that particular section of the bill, getting at it is going to require some kind of a list to work on. Could you provide that if you're not able to be there on Friday?
I would certainly work on that, yes.
Thank you.
Yes, Representative Lakis.
Thank you. Maybe this is already covered by what Representative Schmidt asked, but you read off a number of sections you had issues with. If you could provide written testimony with that, if we don't already have it.
I can certainly,
Provide that.
yeah, we can
We can provide this letter.
give you
Right.
the list that we
Yep.
just had.
Thank you.
Anyone else? I do have one question. You're the second people now to testify that repeals are a concern within this bill. During its creation, during the process of it, were the boards invited into the conversation as to how this was going to be developed?
I don't have any information on that.
Not that you
question.
are.
I'm not aware of that. That hasn't come up in any of our recent board meetings.
Okay, very good. Well, thank you very much.
Thank you.
The chair will call Douglas Osterhout and Mike Porter, representing OPLC. Morning. Not yet.
There we go.
Yep.
Good morning. I'm Mike Porter. I'm the Investigations Bureau Chief, OPLC Division of Enforcement.
Good morning, Mr. Vice Chair and members of the committee. My name is Douglas Osterhout, and I am currently General Counsel for OPLC. Executive Director Courtney gives her apologies for not being able to be here today. She's currently back on her way back from Washington, D.C., but she will be at the subcommittee meeting on Friday, as will I. So I do have the ability to answer questions today, but just so everyone's aware, I'll be at both. I think Representative McGuire did an excellent job of sort of presenting the bill. OPLC does not take a position on the bill. We were actively involved in the SB 330 study committee that occurred last year. We were asked at the end of that study committee to propose language that would meet the recommendations of that subcommittee. So I do have some of those listed today. But I think we've heard a lot of those already. It was the main point of that was to carve out sort of responsibilities between the boards and between the OPLC. And a lot of that came down to who would process licenses. I think there's a lot of concerns, and I can either address things today or we can wait till Friday. I think that's sort of a little guidance as to how you would like me to approach.
I think for the most part, we'll leave the larger detail for
The
the Friday
nuance. All
subcommittee.
right.
Yeah, I
Okay.
think that's where a lot of that will happen.
Okay, so then just the broad overview then. We carved out the sort of discipline and process, but the administrative side. So council for individuals, hearings officers, when investigations could be triggered. Previously, if we were to receive a complaint, an investigation would need to go before the board. We would need authority to investigate. And this is just one example. Oftentimes, depending on when a complaint would come in, there could be significant delay in actually investigating. This just does things like give the OPLC the authority to begin investigations immediately as soon as a complaint comes up. The overall arching theme of this entire bill is OPLC controls the process, right? Licensing applications come in, we're able to process applications. If there's any difficulty, if there's any denials, if there's any discretion, those things go before the board. Complaints come in, we review those complaints in the first instance, we're able to investigate them. We make recommendations to the board. The board still retain the authority to make the decision on whether to proceed with discipline. They still have the authority to hear the case and decide if discipline is appropriate. They still have the authority to make the sanctions. That's all in their control still. Other things that are still in their control. The license might come into us. We might do the criminal background check. The boards still have the authority to set criteria for what needs to be contained in the application. The type of education that's necessary, the kind of on-the-field training, those sorts of things. All that criteria still set by the board. We're processing the license as an administrative function. So these are the types of changes. There was mention of a non-lapsing fund. Currently, at the end of the biennium, OPLC, any funds will lapse into the general fund. It was the recommendation of the subcommittee that the funds, OPLC being a self-funded agency, our money comes from the licensees. And the belief was that money should be spent on the licensees. So the non-lapsing fund was created or was proposed in an effort to keep that money where it should be, hopefully lower costs because we aren't resetting back to zero every 2 years, and then also allow us to retain some money for basic functions, maintaining laptops, new desks, the sort of regular requirements of an agency. I think a lot of the other information that I could present to you today would be probably more appropriate for Friday. I do have responses to the Board of Psychology's letter, written testimony today. I also provided, before the hearing started, written testimony. Everyone should have received a copy of that from the executive director, sort of explaining our position. So we are here to answer questions if you have any. And again, we will be present Friday.
Great. Before we do that, would you mind just giving some brief responses to the Board of Psychology? It would give us a sense, I think, of potential other conflicts that will come up. We won't have to go into every group in detail, but
Absolutely.
some rationale for why certain things were repealed would be helpful.
So I know you don't have a copy of the board's written testimony in front of you, but essentially, as Attorney Eaton went through and read the 4 bullet points, I have responses to the 4 bullet points. So bullet point 1, reference privacy in medical records, RSA 329B26. And in the proposed language, page 7, line 34, the proposed RSA 310.9, section 4, says allegations of misconduct received by the office, information and records acquired by the office during an investigation, reports and records made by the office because of its investigation shall be held confidential and shall be exempt from disclosure requirements under RSA 91A. And then it goes on, unless such information subsequently becomes part of a hearing or publicly disclosed. We believe that captures the entire investigative record is a confidential record. Anything in that record is a confidential record, not subject to 91A or any other disclosure.
Okay.
Outside of the hearing process. Bullet point 2, reference summary of findings from an investigation currently shared with the licensee before facing settlement, RSA 29B22-9. If you look to RSA 31010, proposed language 8, which is on page 9, line 24, at any time or during disciplinary or non-disciplinary remedial proceedings, complaints may be dismissed or disposed of in whole or in part, A, by written settlement agreement approved by the board, provided that any complainant shall have the opportunity before a settlement agreement has approved by the board to comment on the terms of the proposed settlement. It is a nature of settlement agreements to review stipulated facts. I used to litigate, I'm unaware of a situation where an individual would settle a case they're involved in without at least having understanding of the facts and stipulating to the facts. That is a nature of settlement agreements. Bullet 3, which references 329B22-8, requires immediate notification of an allegation. RSA proposed 310.62, which is page 5, line 35. Rulemaking authority. The executive director of the Office of Professional Licensure and Certification shall adopt rules relative to RSA 541A for the following. 2, such organizational and procedural rules necessary to administer the boards in the office, including rules governing the administration of complaints and investigations, hearings, disciplinary and non-disciplinary proceedings, inspections, payment processing procedures, and application procedures. Already in place as of August of last year is PLC Rule 20404, initiation and conduct of investigations. When an investigation occurs, an investigator shall contact such persons, conduct such inspections, and examine such records and other documents as are reasonable and necessary to make a recommendation as to whether further action should be taken based on the allegation in question. The practice of the OPLC is when a complaint is received, one of the first things we do in a typical case is to reach out to the subject of the complaint and ask for a response. There may be situations here and there where at the request of a law enforcement agency, we hold back, but that is standard practice. That's how it works, and it's in rule. And then the final bullet, Bill repeals 329B22X, which will lose the distinction between a status of an allegation versus a complaint. RSA 310.9.4, which is in the bill, page 7, line 34. Allegations of misconduct received by the office, information and records acquired by the office during an investigation, and reports and records made by the office because of its investigation shall be held confidential. It is the same logic or language as before that I already cited, so I'm not going to read it to you again. I'll save you that. But from the office's perspective, the complaint is just the vessel through which the allegation, right? A complaint is the form. The allegation is on that form. We aren't making the distinction at the OPLC between the complaint and the allegation. We don't see there being a functional distinction between a complaint and an allegation, other than one might be a piece of paperwork, one is the words on that piece of paper. So we don't, hopefully these answers alleviate some of the concerns. We're very concerned about the confidentiality of our records. We're very concerned about the privacy of the citizens of New Hampshire. And these things we believe have been approached in the proposed language. So that's what I had for the Board of Psychology. You, Representative Simon, Vice Chair, also had a question about were the boards given an opportunity to get the public hearing, SB 330, it was public. Many members of boards did come and testify before that study committee last year and had an opportunity to provide input into sort of the final product. So, and the recommendations that came out of the board.
Great. And, yes, Representative Schmidt.
Thank you, Mr. Chairman. Perhaps I can, I'm very appreciative of the testimony you've offered up to this point, and I know you're going to be available on Friday, but perhaps where we have the whole committee here and also a number of practitioners and their board members and so forth, perhaps I can drill down into one thing that I think will be understandable to the group, even if this is a first investigation of this sort that they've done. And I was part of a subcommittee about, I don't know, 10 or 12 years ago that involved former Representative Neil Kirk and former Attorney General Sarah Blodgett.
Representative Schmidt, we have a ton of pink cards, so if we could get to the question quickly, that would be
And
great.
here comes the question. So the issue at hand at that particular time was the privacy of individual patients' records who have seen psychologists or other mental health practitioners, and it was recognized, and the statute was amended to bring in the idea that these records needed to be absolutely secure, and they could not be made available in a large scale for some kind of, I don't want to call it data mining, but if you were after a psychologist, perhaps for a billing violation, you didn't really have to see that the records of the patient, their actual consultation with the psychologist. And the idea that that potentially is going to be repealed here is very troubling to me, because people go to mental health practitioners, obviously, for consultation with regard to their deepest issues and problems. That cannot be available to anyone other than the psychologist and the patient, in my view. So this proposed repeal, how will that be handled?
Thank you for your question. So right now, every piece of paper that we receive during an investigation, an ongoing active investigation, is held confidential. If the matter reaches a level of adjudication where the board has determined that this matter needs to be heard before the board, certain aspects of those records would become public. But I also want to say that and I'll use juveniles, for example, juveniles or sexual assault victims and so forth, those can be heard in non-public. There are certain documents that would remain sealed as part of the record. The respondent, the licensee who's been charged, would have access to review it to prepare their defense for due process purposes. But at the end of the day, every document we receive is held under confidentiality. Part of an investigation and we run into this with attorneys all the time, defense counsel, or when we're trying to subpoena records, oftentimes they require a subpoena under HIPAA, and then they will determine the records that need to be sent. And sometimes we have, spirited conversations on those. But records that we receive from healthcare providers are held to the strictest of confidentiality. And even during the hearing process, at times, boards will go into non-public, even during a public hearing, to discuss sensitive information. That is ongoing now. We had a medical case. We had a couple of medical cases, a couple Board of Nursing cases. One involved a juvenile who was severely abused, and they were able to go into non-public to discuss those very sensitive records while still giving the respondent due process, because that's the key here. So I hope that answered your question.
We'll look at it more on Friday. Thank you.
Any other questions? Yes, Representative Gerhard.
Thank you, Chairman. As far as there's no fiscal note, I'm just curious as to how much do you expect? It says it hasn't been calculated. So, as far as the workload that you expect to increase, do you have any idea? I'm just looking at how much of the fee is going to go up now for the licensees.
Thank you for the question. Actually, I think the opposite is true. I think what we're doing is putting ourselves in an opportunity to lower the fees for the licensees, both by streamlining processes across the board, lowering costs, and then also with the non-lapsing fund, the ability to use those funds for things down the road. The goal is to lower fees for licensees.
Thank you.
Yes, Representative O'Brien.
Thank you, Mr. Chairman. Just a quick question. Can you answer under 91A, there is that, like you say, cause for confidentiality reasons when the person may be harmed, or such in the case of HIPAA and everything else like that. Could you quote that number so that the committee can research it themselves and see exactly what it says?
RSA 91A5.
A5.
Yes, sir.
Thank you.
Other questions? Yes, Representative True.
Thank you, Mr. Chair, and thank you for taking my question. Somebody had testified earlier, I think it was an electrician, but I'm not sure, that he was concerned about the board, the electricians board being stripped of its authority, and why would people want to be on the board anymore? I thought I heard you say that the boards would not be losing. Could you address that?
Absolutely. Thank you for the question. I think that's a good point of clarification. So some of the authority that would come away from the board would be sort of kickstarting the investigation, would be appointing the hearing officer, would be appointing counsel to adjudicate the matter. Again, that's all process related. These are things we are currently doing. Currently, we have to wait for board approval to start an investigation, which can cause significant delays. The boards, however, would still retain the authority to set the criteria necessary for licensure, including education, the kind of schooling, maybe apprenticeships out in the field, sort of work experience, those types of things. They would retain the ability to decide whether a matter goes to adjudication or not. They would sit there and be the final decision makers as to whether discipline occurs or sanctions are applied. So really, we're trying to, again, give OPLC control over the process and the board's control over the substance, the criteria. Thank you.
Yes, Representative Grote.
Thank you, Mr. Chair. So I understand that OPLC is trying to go to an online process for licensing. That's a question. I understand. Is that correct?
Yes, that is correct. We currently do have ability to receive applications online. One of the major things we are trying to do to streamline the process, to keep costs down, to improve customer service for all licensees in New Hampshire, all applicants, is a better system. And we actually are implementing very soon a newer, better system for licensees. So that is correct, yes.
Follow up.
So is it necessary for this type of legislation to be carried forth if we want to use that online process in the manner in which you intend to?
I believe so. I think the majority of the language in the bill is sort of pre-existing language in 310A1A right now. And as Director Courtney likes to joke, we're running out of letters. So one of our shifts is to 310. But a lot of the language, it's very, very similar. And then, as multiple people have pointed out, roughly the back 50 pages of this bill is sort of that cleanup language in order just to clarify who has fee setting authority, who can appoint investigators, who can appoint hearing officers, those types of things. Again, clean up for process versus criteria.
Follow up.
So in determining the administration of these things, it's the OPL staff itself that does that, correct? I'm sorry, let me rephrase that question. You're the one under the Division of Enforcement, for example, how those how the complaints are enforced and how basically everything that's underneath OPLC is administered, whether it's through enforcement or whether it's through legislation appearances. It's all done through OPLC. It is your staff that does that, correct?
That's a great question, Representative. So currently I can speak for the enforcement. Not every board has the same complaint process. So we have approximately 54 different boards. And I'll give you an example. Real Estate Commission, every complaint that comes in shall be investigated, regardless of whether it warrants it or not. Whereas Board of Nursing reviews all complaints first, and then those that meet the threshold are then sent to us. Board of Medicine receives a complaint. Board of Medicine is very unique in that we receive written complaints. We receive lawsuits from Superior Court. We receive insurance claims. And then we also have hospitals or other medical facilities that report potential wrongdoing. So there's 4 avenues there. What this does is it streamlines the process for just jump-starting the complaint for the public, right? So for the public, if they feel they've been aggrieved, they don't have to worry about saying, well, geez, does this board do this or that? It's going to be one process across the board for how we receive the complaint, okay? Which in turn houses the allegations inside. That would streamline that for us. And as Attorney Osterhout had mentioned, there have been unfortunate times where there's been significant delays as a result of the complaint process. And I won't give you the specific case. Some delays come in when we have to potentially pull a board together emergently, not for a suspension, but in order to begin what's called an ex parte investigation. We've received information of alleged wrongdoing that may place an individual in jeopardy. We loop in law enforcement, and we ourselves want to get that investigation underway. It can take, because people have schedules, it can take days to get that, when those days, those precious hours, could be the difference. So from an enforcement perspective, this really streamlines the complaint process and how we accept those complaints. The boards are the ultimate arbiter of every complaint. They will decide whether they dismiss it, whether it goes to adjudicate. They wish to issue discipline post adjudication. That remains all with the boards. And then I want to be very clear. Thank you.
Thank you.
Representative Aber.
Thank you, Mr. Chair. A little active listening on my part. So as I've been listening to the testimony, I'm trying to figure out, and I think I finally understand where we're going with this. So what you're saying is you have OLPC on top, and then you've got several boards sitting all underneath. A complaint of anything that could come in that could have legal ramifications comes in where an investigation is necessary to launch it. And what you're trying to do is streamline it at an OLPC level to make sure that it's all treated consistently. So if I compare it to a harassment complaint that we would get in my own company, we have one in a very small example, we have one set of harassment officers. They treat those cases of whatever may come in the same exact way every single time and follow the same policy. And so what you're saying is having several boards and several different people creates more inconsistencies in opening the state up for lawsuits that were treated one way versus another way and very inconsistently. Is that basically what this is? Thank you.
I couldn't have said it better. Yes.
Any other questions? Thank you very much, gentlemen. Lynn Stanley, NASW New Hampshire Social Workers. So, there you go.
There we go. Thank you. For the record, my name is Lynn Stanley. I'm the Executive Director of the National Association of Social Workers, New Hampshire chapter. My testimony will be incredibly brief. We, on the whole, are very much in support of this bill. We applaud OPLC's efforts to streamline what it must be a Herculean task. Our only concern or our primary concern is specifically naming who is on the investigation. And since it can be assigned, we would like to have the content expert be somebody who shares the same license as the person who's being investigated. In the case of social workers, this would be other LICSWs who are also governed by the Board of Mental Health Practice. We will have a representative at the Friday meeting, and I'm happy to take any questions if there are any.
Any questions? Yes, Representative Schuett.
Thank you, Mr. Chair. I assume you have looked at the bill that deals with your particular profession. Did you see anything in that that would indicate that you would not have input as to an investigator?
There is in the language, and I don't have it in front of me, that it may be content experts. And we would just want the language to indicate that there is a content expert, that there is somebody who shares the same license as the person who's being investigated. But if I can continue with that, we absolutely see a benefit to having somebody who is experienced with due process, law, administration, also being a part of that process.
Any other questions? Yes, Representative
Can you
Schmidt.
be available for the subcommittee on Friday?
We will have a representative there on Friday for the subcommittee.
Thank you.
Absolutely.
Anyone else? Thank you very much. Celia Oliver, PhD, New Hampshire Psychological Association.
Good morning. I'm Dr. Celia Oliver, and I'm very happy to be here today and to speak with you. I am representing the New Hampshire Psychological Association, and that is a state chapter of the American Psychological Association, and is a nonprofit member professional supported organization. So I'm here today to provide both verbal and written testimony on behalf of NHPA, and we are essentially supporting this legislation, and along with our colleagues at the Board of Psychologists Licensing Board and to a somewhat lesser extent the social workers, although we have a lot in common with them, we have a number of concerns. And so we just want to make sure that while we're supporting the intent of everything being streamlined and more consistent, that we don't lose some of the things that are working for us. I know that others have already addressed the confidentiality. I just want to bring it up again. It's an incredibly important aspect of the work that we do, and it's important for the citizens and our patients to have this confidentiality, and especially in circumstances where an allegation might be filed by essentially a third party, like a family member. It could even be an ex-spouse, or where disclosure feels necessary to another agency like law enforcement. So in those areas, you really open yourselves up for information, sensitive information getting out from the medical record. So we are concerned about that. We're also really concerned about this differentiation of allegation versus complaint, because for us, along with a number of other mental health providers, we're constantly being re-credentialed, and we're asked in these re-credentialing applications, is there any pending complaint? Well, if something is an allegation, then we're under no obligation to report it, and that allegation could be something very trivial. So of course we're not going to report that. But if it has moved into a complaint, then we are required to report that. And most likely, our credentialing will either be denied or severely restricted. So that distinction is very important to us. Also, as the Board of Psychologists has pointed out, knowing that an allegation has been made, because we are treating very sensitive, potentially volatile cases, and we need to know that something is not going right with this patient that we might not have been aware of before, although, hopefully we were, but sometimes that happens. So we need to know what's going on. We need that done as quickly and timely as possible. And then in terms of an investigation of potential misconduct, again, like our colleagues, the social workers, and along with the Board of Psychologists, we're very concerned about who's being assigned to those investigations. Our profession, like many others, is very complex and it has many subcategories. I've been a licensed psychologist in New Hampshire for 25 years. And so I was licensed originally with the Board of Mental Health Practice and then under the Board of Psychologists. Been very active in the profession for all those years. And in terms of investigations, because we have such complex areas of specialty, I would not, for instance, be at all qualified to investigate one of my colleagues who's a neuropsychologist. I'm a clinical psychologist. I would not be able to understand the nuances of their profession well enough to make an ethical investigation. So I'm very concerned, not only that the investigator is licensed as a psychologist, but also that there is some sort of pool of investigators that can be pulled from that matches up a neuropsychologist with a neuropsychological investigation. And that this pool of investigators, because if you only have one expert, then you can imagine how there's opening for personal bias that maybe that investigator isn't even aware of. But if you're working together, then your colleagues can hold each other accountable. And I always believe more brains are better than one. So these are some of our concerns. We will have a representative at the working committee on Friday, and that is John DeJoy. And so I am open to any questions or anything I can provide, and I appreciate you hearing my testimony.
Thank you. Thank you for your testimony. Any questions? Yes, Representative Hebert.
Thank you, Mr. Chair. So what you're asking for is more of an accountability from OLPC during the investigation back to you?
Back to the individual licensees, yes.
Follow up?
Follow up.
I think what you mean is accountability back to the board, not back to the licensee. Is that correct?
It depends on the situation that we're talking about, because a specific allegation would be about a specific licensee. So we would want the licensee to be informed and fully kept apprised. There would also be circumstances where we would want the board who is making the disciplinary determinations, and I think possibly other decisions prior to that, where the board of psychologists would be the ones to be notified. It depends on the circumstance.
Follow up?
Follow up.
Wouldn't it be wise for that to go from in the hierarchy pyramid to go from OLPC to the board, an appointed board member? And I would like to hear from the Electrical Association again on that. Thank you.
I am not certain. What I'm concerned about in that potential scenario that I'm imagining as a practitioner is that there would be such a delay if it was going from the OPLC to the board and then to me as the practitioner, where it might be something I need to know directly and as close to immediate as possible. So those are our concerns. And again, this is about how these things get implemented. Thank you.
Any other questions? Seeing none, thank you very much for your testimony.
Thank you.
Michael Phillips, Lamora Psychological Associates.
Thank you, Mr. Chairman and committee members. I want to speak about this bill in a couple of ways. One is that there are parts of it that I support. I believe that there are many ways that we can increase
I'm sorry, Mr. Chair.
Yeah,
Can you please,
sure.
can you also please restate your name because I
Sure.
and
My
who you
name is
are.
Dr. Michael Phillips. I'm a clinical psychologist and I'm the owner of Lamora Psychological Associates. It's a practice in Nashua and in Bedford. I was present during the hearings about 10 to 12 years ago where we revised the protocols for the Board of Mental Health Practice to address some of these issues. And despite what the counsel for the OPLC had said about these things never happening where licensees would not be aware of the strength of the case against them. That was routine practice before we reformed the rules, going through GELCAR 3 times against the Board of Mental Health Practice back then. In addition, licensees were not informed that they had complaints against them at that time. And we had situations where there were people who were unstable and they would generate a complaint, and that could create risk both for them and for the psychologist who continued to treat them while we were waiting to be informed that there was in fact a complaint filed. These are the things that we were concerned about back then, and that's why we argued for those rules, and they got those rules in place. And we're now looking at having all of that revoked again and recreating those dangerous situations in practice. And that's really important to us. I have a number of objections to this bill. I'm going to limit my speech today, and I'm going to submit written testimony to be considered on Friday. But I want to just kind of talk about it more globally, because I think that we have a balancing act here. On one hand, we have administrative simplicity or efficiency, and on the other hand, we have accuracy and justice. And we can't lean in either direction on this. We have to balance both. I mean, if you want to get administrative simplicity, we could flip a coin every time a complaint comes in. It would be really fast. We'd have a decision immediately. We would have very little justice and accuracy, right? Nobody's proposing that we do that. But I believe that this bill leans heavily in the direction of administrative simplicity, and it costs us in terms of justice and accuracy. I think that right now, we're trying to simplify a process for 53 very different boards, or 54 very different boards, into one routine process. It's one size fits all. And as a really big guy, I've had familiarity with one size fits all, and typically it's one size fits no one. And I think that's what I'm trying to avoid in this kind of a circumstance. You know, the intent, as stated, is laudable, that the boards are going to retain authority over profession-related information, and that you know, that the nuts and bolts of, you know, administering licensing and things like that is going to be with the OPLC. But that's not what the bill says. The bill doesn't say that at all. Basically, you know, what they do is they tend to take away all of our rulemaking authority. They take away our ability to run the hearings and write rules that would regulate the hearings. And so I think that these are significant pieces that we would need to be able to have an effective and fair set of solutions when we're adjudicating hearings. They define us as triers of fact, but the investigation is conducted by the OPLC, not necessarily with professionals that are informed about the ethics of our profession, which are very complex, or even the professional specifics. The presiding officers are appointed by the OPLC. The procedures in the hearing are written by the OPLC, again, in a one-size-fits-all kind of a fashion. And that's not going to work. It didn't work in the past, which is what led to the effort to reform all of these rules 10 to 12 years ago. And now we're aiming back in that direction again, and I think it's going to be a big problem. I think, at least with psychologists, in addition, there are some unwarranted increases in penalties that are going to create a potential burden on licensees. The potential fines have been increased by 50%, from $2,000 to $3,000 for an individual fine, and $200 per day to $300 per day, but that's really the smallest piece of it. Section 310:12 Roman 5 grants the ability to charge the licensee for the cost of the investigation and the prosecution of the complaint against them. This, I believe, is an egregious violation of due process. It builds upon a previously passed statute that RSA 332-G:11, which somehow passed in 2016 without commentary from a single board. At least that statute had a $10,000 limitation. As it's proposed within this current bill, there is no limitation. So if there's a $100,000 investigation or a $500,000 investigation, you know, they have the ability to enforce that, the collection of that, onto a licensee. That, to me, seems completely unfair. In addition, the standard of proof in licensure complaints is very low, from somewhere, depending upon the issue, preponderance of the evidence to clear and convincing evidence. That's between 51 to 75% certainty. The standard of proof in criminal cases is beyond a reasonable doubt, which is typically thought of as about 95% certainty, right? But in criminal cases, they don't charge for the cost of the investigation to the criminal who's being charged, and so we're looking at this huge potential penalty to be enforced upon licensees, and I gotta ask why. And I think one of the things is that it goes back to what we talked about initially. The way the boards used to do business is they would sit you down and say, this is what we're offering you. We're not going to tell you the strength of our case against you, but it could be a lot worse if you don't agree to a settlement. And they would use that leverage to achieve settlements. And this is pre-2010, right? So it's a long time ago. Since then, things have gotten a lot better. Back at that time, we were identified as the most dangerous state in the country to practice. And we couldn't get psychologists to come to this state, okay? Since then, that's not the case. Psychologists are coming here regularly. Our population of licensed psychologists has grown. I think that's a good thing. I don't think the solution is just open the doors to make licensure easy. I think we want to bring in competent, qualified people. We want to hold them to good standard of practice. We want to be able to enforce penalties as we need to if they violate those standards. But we don't want to make it so onerous that nobody wants to come and work here. That would be a bad outcome. And I think that's where that's headed. I think we can do much better than this. We need to do much better than this. I think this bill needs a lot of work. It's like a cake that's been in the oven for about 20 minutes. It has some shape, but it can't hold its own and it's not ready for consumption.
Thank you for your testimony. Any questions? Yes, Representative Schmidt.
Thank you, Mr. Chairman. Good morning, Dr. Phillips. So you referenced a moment ago an increase from 2,000 to 3,000. Is that up to 3,000 or is it 3,000 on the nose?
I think it's up to.
Up to.
Yeah.
Okay, so there's some reflection for increased costs and so forth. So it still could be 1999 as opposed to 2001, right?
It could be. I think in many kinds of cases, you can have protection against claims like that where your insurance will cover the cost of fines. I consulted with the APA Trust, who I have my malpractice insurance. They don't cover the cost of fines. And so that would come out of my pocket, not just the 3,000. If I had to pay for the investigation, my malpractice insurance would not cover that. That would be a direct bill to me.
Thank you.
Anyone else? Seeing none, thank you for your testimony.
Thank you.
I have to apologize. I can't quite make out the last name, but Robert Wallace, maybe? Board of Psychology? Oh, those you. Okay, so we're good on that. Elizabeth Pop? If you could turn your microphone on, please, for us.
Oh, did I turn it off?
Thank you.
Okay. I'm Elizabeth Rupp. I live in Manchester, New Hampshire. I am a licensed acupuncturist. I neither serve on the board nor am I part of the state association. I've been before this committee before to say that neither one of those organizations represent me or my coworkers. That's why I'm here. I work at a low cost, high volume practice, whereas the rest of the acupuncturists work more in a high cost, low volume practice. So I'll come to the subcommittee meeting. I just saw that acupuncture was in this bill. I can't even find it right now because this is so long and I saw things were being repealed, but I couldn't tell what. So I'm just here to find out more. Do you have any questions?
Any questions? Seeing none, thank you very much. Kelly Lutke?
Mr. Chairman, maybe we could have people with somewhat unusual names spell their names because I don't like approximations in that regard.
Would you mind spelling your name, please?
That husband of mine gave me this name. Lue, D as in David, T as in Tom, K as in Kelly, E as in Echo. Can you tell I've spelt that a few times? Good morning. My name is Kelly Ludke. I am the board chair for the LADAC board. And I have been involved in the LADAC board probably, since 2011. Oh, I'm sorry. It's the Board for Alcohol and Other Drug Use Professionals. So I've been involved with the board since about 2011, but I'm testifying as just a licensee, as an MLADAC in the state, because my board doesn't meet till tomorrow, so I didn't get a board vote. I'm going to keep this brief. I have a few things I guess I wanted you all to know, which is I wasn't even aware of this bill until about 4 days ago. So that means I was never approached and asked for my opinion on any of this during the study committee. So I felt a little blindsided by it. And I want to say that I believe in a spirit of collaboration, of working together. And so the testimony that I prepared is written. I'm not going to go through each of them. I'll submit this. But I feel like this bill really does strip the authority of the LADAC board. I feel that the OPLC coming in, because when I first came on the board, there was no OPLC. We met at the Bureau of Drug and Alcohol Services and we did everything ourselves. And it was cumbersome, it was burdensome, it was difficult. So when OPLC came in and they said, hey, Kelly, we're going to assign you a lawyer that you can consult with. I'm like, wow, this is great. We're going to assign somebody to do your investigations. Great. I love that. It really took a lot of burden off the board. However, I don't believe at this time the OPLC is ready to take on all of the administrative duties that it's asking to do with repealing so many of our state statutes. One very quick example would be one of the first laws they were trying to repeal is the board not having the authority to have an advisory committee. Why? What is the purpose of that? We need our advisory committee. We have one called the peer review committee, and they are essential to getting our work done. Right now, our average board meeting begins at 8 a.m. and ends at about 5 to 6 p.m. We're volunteers. We all work full-time jobs. If we didn't have our peer review committee to review all new applications for LADAC, MLADAC, CRSW, and LCS, we'd probably be there until midnight. I mean, this is an essential committee to us. And there's a law, in this bill, they want to repeal us being able to establish those advisory committees. That doesn't make any sense to me. There are other things where they want to take our rights away, our duty, our authority to conduct our own investigations. Right now, I believe that our investigations oftentimes need a person with expertise to maybe work collaboratively on the investigation. And I really think the work that the OPLC has been doing has been wonderful. I'm not here to say anything bad about anybody, except I think we can work together. I don't think we need to repeal state statutes to get the work done. I think there was some testimony around this being streamlined because there tends to be delays from the board. And frankly, that kind of hit me in the heart because I thought, what? I've given an investigation my cell phone number, told them to call me any time of the day with any questions and anything they ever needed. So it doesn't feel accurate to me. I feel like there's a lot more to say around each and every statute that they're asking to repeal. But again, I'll keep that in written testimony. And I don't even know if I'm in opposition of the whole bill. I can only say what I know about the LADAC board. I don't know what every other board does, so I can't say I'm 100% in opposition, but I'm in opposition to every single one of the state statutes they want to repeal for the LADAC board. Thank you.
Thank you for your testimony. Will you take questions?
Yes, please.
Any questions? Seeing none, thank you so much for your testimony. Kimberly Kirkland.
Good morning. My name is Kimberly Kirkland. I'm a lawyer in Manchester and I represent plaintiffs in medical malpractice actions. I'm also the president-elect of the New Hampshire Association for Justice. And I was a tenured member of the law school faculty, first at Franklin Pierce and then UNH from 2000 to 2014. And during that time, I taught two courses which are relevant to what this bill is trying to accomplish. I taught civil procedure, which is the course that teaches students the rules governing the civil process for adjudicating disputes. And I taught lawyer ethics and the course about the lawyer discipline system. I'm here today to talk specifically about how House Bill 655 relates to the Board of Medicine, and I'm testifying in support of the legislation broadly and specifically want to talk about why it will be helpful in improving the functioning of the Board of Medicine. As you all may be aware from the articles in the Boston Globe and the Manchester Union Leader this summer about a surgeon who had over 20 malpractice cases against him, but had had no action taken against him by the New Hampshire Board of Medicine. The Board of Medicine is not functioning well. The Globe Spotlight series looked at the rates of physician discipline across the country and found that New Hampshire has the lowest rate of physician discipline in the entire nation. And with respect to the surgeon who was the focus of that Spotlight investigation, there was no other surgeon in the country who had had as many malpractice claims brought against him. So there's something wrong with how the Board of Medicine is currently functioning. And I think when the folks from the OPLC were up here, they mentioned that the Board of Medicine has actually been treated differently. And so the rules of the OPLC, the rules that this statute would apply, would bring the Board of Medicine process into conformance with the process that's applied to other boards. And I think the problem that has existed with a Board of Medicine is really a result of the fact that they've been treated differently. They've had a system where they, from start to finish, have discretion to police themselves. And I think all of us know, all of us have had the experience that it's hard to call a colleague out. It's hard to say to a colleague or impose some punishment on a colleague. That's something really difficult to do. When I was teaching at the law school, I remember teaching big classes, 150 students, and the time it came to be doing the grading for a very foundational course that was a real screen for who was competent to become a lawyer and who wasn't, I was going to need to fail people. And my grading, the grading at the law school, was anonymous. It was far easier for me to honestly and objectively grade an exam when I didn't know whose it was. And I think that's what this process is going to bring to the Board of Medicine. It's going to take that original screening, the complaint will come in and be handled by the Office of Professional Licensure and Certification instead of the Medical Review Subcommittee of the Board of Medicine, which is where that current initial screening happens. And the Medical Review Subcommittee is a committee made up of volunteers, physicians. It's a small committee, and they often don't have the expertise. The members of the committee don't have the expertise to actually be evaluating the conduct of the physician involved in the complaint. You might have a psychologist looking at a cardiology claim. By bringing all of this into the OPLC, having OPLC do the first level of screening, bring in people with subject matter expertise for that investigation, and then hand it to the Board of Medicine for a determination of whether it goes further, and having somebody, a professional and unbiased person from the OPLC, making a decision about how best to prosecute that claim in front of the Board of Medicine. That's an objective person kind of serving in the role of the prosecutor of the claim. I think we're going to get better outcomes from the Board of Medicine. So the effort in this legislation to bring the Board of Medicine's processes into line with those of the other boards will, I think, improve the quality of the evaluation of physician conduct that the board has to undertake. I'd be happy to take questions.
Thank you so much. Any questions? Yes, Representative Schmidt.
Thank you, Mr. Chairman. Thank you for your somewhat disconcerting testimony with regard to the Board of Medicine. But you've highlighted advantages in the contemplated process of this bill. Do you see any deficits with regard to some of the issues that have been raised by previous witnesses?
I have not looked specifically at issues relating to the psychology board, the social worker board, or the board relating to alcohol practitioners or electricians. But I would say that from what I know of the Board of Medicine's processes, I don't anticipate that there would be issues with confidentiality, which is what came up and I think would be, of concern. I didn't see anything in the bill that made me think that there was a risk of confidential information becoming public, that the board can still do everything it would do now if it was holding a public hearing to protect the confidentiality of the patient making the claim. So that didn't seem like an issue to me.
Yep, follow up.
Thank you. So your experience that you alluded to, your background would make you, I think, a valuable member of the pool of people involved in the subcommittee workshop that we will be having on Friday. Will you be able to be attending at that as well?
I can do that, yes.
Thank you.
Any other questions? Seeing none, thank you very much.
All right, thank you very much.
Stephen Raincourt, ECBA.
Good morning or afternoon. No, still morning. Committee chair members. My name is Stephen Raincourt. I'm a licensed electrician in the state of New Hampshire, and I'm also the executive director of the Electrical Contractors Business Association. I'm here representing them as well. I did take quite a bit of time to go through the bill and make some notes, and I don't think you guys want to hear it all right now, so we'll probably save that for subcommittee. Maybe I'll get some brownie points for that. I did have a few points that I wanted to make, and I'll kind of just put them out there, and then whether you want to have some questions, discuss them, or go to subcommittee, we can do. Some of the concerns that have been brought up, or we echo as well, the concerns of allegations and complaints. Just a brief little stories to what happened to me. When you have this allegation and complaint, we're concerned about how it's treated. If you just have a standard and they don't have the impact of the, or consult from the board or somebody, because a complaint was issued against me some years ago. They called up the state, they complained about me, and I got a call from the state inspector. We discussed the situation, I explained to him, and what happened is the customer I was hired by a contractor. I was working for the contractor. The contractor did not call me back to go and finish the electrical work because he wasn't getting paid. The homeowner called the state and complained and put an allegation against me. And I had to go and protect and defend myself and explain to him that. And we came to a compromise, but you know, an allegation or a complaint has to have some merit to it. And the boards are the most qualified to do that. If you start a process that just is, here's what we do, A, B, C, D, it takes away that information and that knowledge. This was simply about money. He wasn't paying the contractor and he was trying to force me to finish. And he went and had some other people do some work, the well company, and left a mess, and they put that on my complaint. So just as an example, there's a lot more to it than just I file, you know, someone files a complaint. If you file a complaint or allegation and it's not, it's the board decides it wasn't, you weren't wrong, you didn't do anything. What happens to all that paperwork and information from confidentially? Does it get expunged? Stuff like that, right? So there's a lot with that whole issue that's concerned without getting the input from the board. Again, which goes back to what they're repealing, the board's authority, so to speak. When they talk about repealing the authority and there's still plenty there, yeah, they're taking all the meat and potatoes. You know, they're just, it's showpiece at this point when you start taking half of this away. The rulemaking authority, the fees, license renewal, disciplinary action, hearings, appeals, investigations. I mean, you know, you can see what the board has, and the highlighted ones are what they're taking away. And I can provide that, I'm sorry. But, so that needs to be looked at a little better. It's not a fits all for this. Every board is different. We've had pretty good luck as our board not having some of the issues that have been brought forth to you. And we think that it's going to be difficult to use the one size fits all to fix this completely. The confidentiality, who has access to it? Does every employee in OPLC have access to it? How does that work? And I'm sure the people behind us can explain that. But again, these are just questions that we're concerned about. There's a lot more employees in OPLC than we used to have on our board, electricians board, right? We had maybe two people who did the admin. That's all that might have access to it for us. Now, is there 100 people in OPLC that has access to all this? Or does it stay under the investigations and only a few people? Some concerns with the turnover and just because of the size of OPLC. Had a discussion with someone that the other day that a couple weeks back, they had a meeting, almost 50% of the employees are new. What do they know about electrical, health profession, medical? And they're processing this just based on this agenda. While we think the procedure and trying to get consistent is important, there's got to be a fine line. Balancing the political and the justice as well as the administrative simplicity, as mentioned earlier, is very important. Maybe breaking up into 3 sections like Representative Inventine mentioned, so that maybe some of the laws apply to the 3 different sections and it's still somewhat easy to administer. Fines are in there, you know, and that's something new. You talk about $3,000 in fines for a licensed electrician, depending on, but they're not as stiff for the non-electricians. When they do an investigation, what do employees from the OPLC know about wire rating, termination, or installation methods? They don't. But they're going to determine whether this is a just cause, and then do we need to hire somebody? It's in the bill. They can hire somebody when our board has the expertise. With our state inspectors, we have licensed electricians on the board, and as many other boards do. The content expert, again, I think that our board can provide that and don't necessarily need to be hiring somebody every time. So those are some of the changes. And just again, that it's, you know, it seems like 10% of the boards that are having problems are affecting 90% of the boards that don't. And hopefully we find a compromise in there. We don't disagree with the administrative part and trying to make it consistent and find some methods, but we feel that there's some middle ground that needs to be addressed. And we'll conclude.
Thank you for your testimony. Any questions? Yes, Representative Abear.
Thank you, Mr. Chair. I get exactly what you're saying. A little active listening is that you're saying that the board needs to be part of that process. And if there was something added to say that an appointed board member would ride the investigation with OPLC, would that make this better?
It would definitely help. I think we'd have to see the wording because as it also talked about from the very beginning of the allegation, was somebody, when my particular situation, the state inspector, the chief electrical inspector is the one that called me. I explained to him the situation. He understood what was going on and he simply asked me, will you go take care of that so we can just put it to bed? So I went back and finished it for free and did stuff just to make it right. But so at the very beginning as well, I guess, not just during it.
Follow up.
Follow up. I can absolutely understand why it's essential to have somebody that's from the field to help with that initial investigation, as any complaint that comes through is not just a plain it's harassment. It might be that in your case, I was installing conduit 2 feet down, 3 feet away from the deck, blah, 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 blah. OPLC may not quite understand the full complaint. Is that what you're saying?
That's correct. Without that expertise and those employees that are taking that information in don't have that. Yes.
Thank you.
Yes, Representative Gerhard.
Thank you, Chairman. Making the complaint info public, you're against, because it could be just arbitrary. But with online reviews these days, does that really matter? I'm just wondering, especially electricians, let's say, are people doing some background before they hire an electrician, or the contractor that's hiring them and their subs, they know who they're hiring, would you say? I'm just wondering if that's as much of a concern, because like with the hospital situation, having those complaints public, somebody's going in for surgery is going to do, whoa. So I'm just wondering if there's...
Thank you for the question. I think that it varies based on the profession because most electricians, we're not online, we're working. The customer might go and look, but honestly, I don't think you can put good reviews online. We happen to know of an electrician that lost his license and you go online now, he's advertising something else, he's got all these great reviews. His license was revoked by the state of New Hampshire and he's still doing work. So I don't know how much weight it plays into it. Some people do the diligent background and check, but I don't think a lot do. So I don't think the online part is going to show that, my situation was put online or something, because he may post something on there, but I don't know how it would affect compared to having somebody involved to make sure that it wasn't just a harassment type of situation.
Any other questions? Seeing none, thank you so much.
Thank you.
Deborah Warner.
Thank you so much. I am so happy to be here. It is a privilege to be able to testify. I'm Dr. Deborah Warner. I'm from Littleton, New Hampshire. I'm representing myself and my practice, Bright Day Psychology, PLLC. I have been in practice for decades. I have had occasions to work in private practice in a nonprofit agency, which I directed for more than 10 years. In the state system, I worked for the GOC and also youth. I also worked for the VA. I've had a lot of experience in different settings, and I've supervised many psychologists and other mental health professionals along the way. I'm very well informed about this legislation and also what led up to it. This legislation is 18 days old. It's just a little one come out of the nursery. I can say that the boards were not consulted. It was not under development. In the study committee that happened last year in September, I regret that I was not able to attend. I had COVID at that time. All better, real good. And so it was, there were no board members or boards represented on that committee or testified on that. There were no professionals. There were no professional associations who testified in that study committee. It was, all the representatives and the senator, and then representatives from OPLC. That's who came up with this. And so it's kind of one-sided, I guess I'd say, in terms of whose perspective is represented here. I want to bring up some points. I am in full agreement with the points made by the Board of Psychology. And there are many more points as well. I'm going to go over them globally and correct some misunderstandings that seem to have come about. The privacy of medical records is not really, it was 2 years in the making with Representative Neil Kirk a dozen years ago. I was involved in that process. That's how I got to meet this board originally. And it's not about locks and keys and security, or about any of the esteemed attorneys doing badly or anything, or leaking documents or anything like that. Mike Porter's a very good attorney. I appreciate how disciplined he is at his work. It's not about that. The privacy of your medical records is that when you make a complaint to the state about your conditions of treatment, whatever board it was on, inside of that is the understanding, and also in the statute for the psychologist, it is exactly that when you do that, you are waiving your own privilege of confidentiality on your own notes, and that they can be shared with the state so that it can be evaluated. And that's important. That makes sense. But if you are subject of a third-party investigation, let's say your ex-spouse thinks that your psychologist did a bad job because they divorced you. Those records of your spouse or you are then absconded, they're taken to the state. This point of this medical records privacy is that they cannot be taken because they're a third party. They cannot. Your records cannot be released without your knowledge and consent. Now, the board in the process of an investigation might say, well, we think there's incompetence going on. We need to see a pattern across patients. Hey, Dr. So-and-so, give us 10 more patient records. This statute that was brought about through a 2-year process that involved a House concurrent resolution, unanimously passed, and bipartisan legislation from the House and Senate that was unanimously passed to protect your records from being taken in these third-party cases, in the expansion of an investigation. That way your records don't go somewhere to the state without your knowledge or consent, and they don't end up in archives, and they don't end up looked at by people that you never even conceived of. I am a psychologist. I take it seriously. People come to me with very precious private issues. It is an honor and a privilege to help them in that space. I keep my mouth shut about that. Their records are very secure. I only release them with their consent and knowledge. And that's what is protected here. It's not that once any records come to the state for investigation that they could be leaked. It has nothing to do with that. It has to do with you knowing, and many people here in the audience or even among the reps might have gone to see a counselor and might have told them private things. I don't think you would want those records taken without your knowledge or consent. That is the point of that. It has nothing to do with 91A. It has to do with your records going into the hands of the state. I can say one of the things that we do need to get things that are operating and so on. The psychology board became independent 9 years ago. And in that time, they've had 13 secretaries. And you wonder why there might be some delays now and then. They're restructuring. OPLC is a brand new place, brand new department. They're restructuring all the time. They're getting things more organized. They're developing. It's a growing, evolving system, which is fine. They're doing things. And we do need to do what we can. But this is, as they said, not one size fits all. And there does There also, I'm going to take my glasses off so I can see a little bit on here. One of the problems with this is on my first page of my written testimony that you can see that looks like this, has my name at the top, Deborah Warner, is that the investigation needs to be defined. It needs to happen when as the way it's written now, when the allegation comes in, OPLC just gets right to work in the enforcement department and starts investigating. That's the way it's written. That certainly there are rules otherwise that will probably fall off as they're made congruent with what they've written in their statute. But you cannot have an undefined investigation go on for a doctor or any of the trades that doesn't have charges in it, that the licensee's not even notified of. There's nothing in here that says they have to be notified. Currently in our statute, the doctor gets notified immediately when an allegation comes in. That's important. And in fact, they are given an opportunity voluntarily to respond. The board then looks at the allegation side by side with the response, and they determine whether it violated the codes and laws and rules, and whether or not it's trivial. I mean, it might be nothing. It might be you don't have enough Kleenex or something like that. They can dismiss it. They can say, oh, this is an allegation. They can say, oh, this is serious. We're going to investigate. They write an order of complaint, and they convert it from an allegation to a complaint. And then they can define that order of complaint also to be an order of formal investigation, where they lay out the charges to be investigated. Those become the guardrails. The scope of the investigation, those are the guardrails for the investigation team. Then it goes over to enforcement, and they get to do that work. That's missing here. A person has a right, a licensee has a right to know something has happened and that they've been complained about. It's, as Dr. Phillips said earlier, it's dangerous to not know if you're treating mental health issues. If somebody has, broken down and they're making strange or even frivolous or unrealistic complaints about them, the psychologist. If the department says, well, this is just crazy, we're going to dismiss it and we're not even going to tell the psychologist, that psychologist doesn't know that their patient is breaking down. That's unsafe for that patient. It's unsafe for the psychologist. They need to know immediately. They're not going to be mean. They just need to know. It's important. There are some other things about that bifurcated process between the allegation and the complaint. Once it's a complaint, it is certainly reportable by the doctor to everybody who asks that they have a professional relationship with. I'm on hospital privileges. I've got insurance panels. I have my own practice insurance. There's medical societies and such that all say, have you ever had a complaint? But our statute says if you have an allegation, that's not reportable. And in fact, insurance companies and professional organizations and institutions are prohibited from asking about an allegation. That's going to be wiped out. That's going to be repealed. So there are things, I understand that the reply from Director Courtney was that this is all 91A stuff, and don't worry, everything's secure. That has nothing to do with it. I walk out of something, and if I have a complaint or an allegation, I'm in a different status for my whole profession. And in fact, if I tell them that I've had an allegation, if I have to, because it's not protected by law, if I then have to tell them, then I'm going to be kicked off of insurance panels, and whole realms of patients won't be able to have reimbursement seeing me. I might still be licensed, but I won't be reimbursable. I might have an upgrade in my practice insurance. I might not get insurance. Things like this will happen. I might be kicked off of my hospital privileges. All of these things can happen because of that. And this is a protection in the law currently. There are I can stop here. I will be here Friday. There are so many pieces of this. I strongly urge the committee to retain this bill. It could be good. I have had experience doing things like this. I will apply myself to this process if you retain it. You'll see a lot of me in those subcommittees. And I'm a good worker, as people know from my past. So have I clarified this thing about patient privacy, that it's not a 91A issue? It's about your medical records and where they go. And okay, thank you.
Thank you for your testimony. Will you take questions? Any questions? Yes, Representative Gould.
Thank you, Dr. Warner, and thank you for coming down.
Thank you, Representative.
Having worked with child welfare, abuse and neglect allegations, and the intake process for that, and trying to consolidate that for the 13 different districts around the state, I cannot imagine trying to do an intake process, a screening process for complaints against so many different disciplines and be able to ferret those out through a central office. Can you talk about how you can envision that kind of a process happening in this case?
Well, I think badly, yes. I think that if you have a small department of attorneys, and they have on occasion they draw in some of the practitioners, and they can call them, and then they look that over. Could be good, but there's nothing in this that says that they need to have a professional of that practice involved in any part of that investigation. The board would not know about an allegation or a complaint until it's done with the investigative process, and then it comes at them in a report. Oh, one other thing that does remind me as well, thank you for jogging my memory. Once the board sees a report of investigation, they then have the duty to determine whether or not to take it further and to do discipline. And they might recommend that there be a settlement offered, which is pretty frequent from what I gather. At that point, the licensee hasn't seen anything. All they get is, in this bill, all they would get is an offer that's 20 pages long of, well, here you're going to have restricted practice, or you're going to be suspended for a year, or you have to do corrective supervision, or whatever it might be. And they've never seen the allegation. They've never seen the evidence against them. Currently in our statute, before they were asked to get into settlement negotiations, they would be given discovery. Now, all of us watch enough TV shows. We know what discovery is, and that's the other side gets to show what they've collected that's relevant to the case. And it's in our statute right now that when you, as a doctor, are being approached for a negotiation, you get to see an accumulation of the evidence that's been assembled against you. You don't get the legal analysis, you just get that, and you get to say, and so you can look at it and you can say, well, was so-and-so telling the truth? Well, I guess, yeah, they're saying it that way and the board's taking it that way. I guess I'll consider settling. I'll talk about it. But if they look and say, oh my goodness, this never happened. Oh my goodness, I wasn't even treating them at that point, or things like that. Absolutely, I'm going to go to hearing. I'm going to do that. Currently, they get that report. If they didn't get the report, after they might choose to go to hearing, then they would get the regular kind of discovery. But it's at that point where you're signing away your occupation that you need that information. It's reasonable to do. And in fact, it's in the law. Now
May I just say something?
Yes.
I think that this is all something that we can talk about at the subcommittee hearing. I'm just, concerned about the time and I'm thinking that maybe this is something we can talk about at the subcommittee hearing on Friday.
Okay, I'll just
Thank you.
I'll say a closing comment then. Thank you. When you are taking away rights and protections that are already in statute, you really need to justify why they're taking that away. I think that's been misunderstood by OPLC, unfortunately, in their rebuttal. But I think the onus is on them to let us know why they could take that away.
Okay. Thank you so much for your testimony.
Thank you
Appreciate
very
it.
much.
That was the last pink card I had. Did anybody else want to testify?
We have the pink card.
Yeah, could I? Would you mind turning your microphone on? Thank you.
Can you hear me okay? Yes. Thanks. Good morning, Shane Goulet with the Office of Professional Licensure and Certification. I'm here on the board, on behalf of the Board of Accountancy in a very limited scope. They met yesterday and reviewed 655, and they wanted me to bring this written testimony. Specifically, their concerns were general in nature. They want further review of it, and they expect further comment for the subcommittee. Their general concerns relate to essential usurping of their authority as it relates to reinstatement, renewals, rulemaking, and the investigative process. I have the written testimony here and have no further statements. Thank you.
Great. Thank you so much. If you wouldn't mind just handing it to the representative and pass it around. Would anyone else like to testify? Seeing no one, I will close the hearing. And yeah, I'll get you the card. And we are on recess until 1 o'clock.
Thank you, it's very kind of you. Representative Susie, how nice to see you. I didn't get a notice that you were replacing Representative Smith. I got one that we were replacing Representative Wilhelm, but not.
I apologize. I had notified our office.
All right. Well, if you say so, I'll assume it's legitimate. But please send it to me. All right. So we are on the plan for today is to vote on our early bills. And the first section of bills listed in the notice are the early bills. The second group is bills that we have heard but are not early, but I'd like to get as many of them out of the committee as possible. But we're going to start with the early bills. And let's see, easy ones first or hard ones first?
Easy one.
Okay, so let's start with House Bill 337, which is about notice of public meetings and an opportunity to comment. I believe that went to the licensing subcommittee.
Yes, Madam Chair, you
Yes,
should
ma'am.
all have amendment.
Amendment number 0180, is that the one?
Correct, yes.
Okay,
thank you.
I have that
And-
one.
And I will first move that amendment. The subcommittee. Sorry. Yep.
Okay, so you're moving on to pass with amendment 0180.
And I'll second.
Yes, 0180.
Okay, so that is by Schuett, seconded by Lekis.
The committee heard during the hearing that the sponsor learned that there was an incorrect RSA site listed, which unfortunately precipitated the FM that's attached to the bill, which does not really apply once that RSA site was corrected. The amendment corrects that RSA site to what you now see, 310-A:1-D as in David. And then some of the language in the actual first section of the bill had concerns for OPLC that their confidentiality clauses were not properly protected. So OPLC and the sponsor worked on the language that you see in this amendment, and they're both happy with it. The sponsor feels that it allows the transparency that he was seeking and the better notice from public meetings. And OPLC feels that the confidentiality that they need is also protected.
Okay, excellent. Representative Lekis?
Thank you. I agree with all that. I'll just expand a little on the fiscal note issue. I know there was some people had concern with that. What happened was they put it in the section having to do with hearings and disciplinary stuff, which meant that everything they were going to release had to be reviewed by a lawyer, which meant they would have had to hire a number of new lawyers. And that was just an error, and this corrects that. The other concern OPLC had was in cases where something had to be dealt with in sort of a, not emergency, but a short-term basis, and there's some allowance for that here. But I think it's a good amendment and suggest we support it.
Does anyone else wish to comment on the amendment to House Bill 337, which replaces the entire bill? So if we adopt the amendment, the rest That's all there is. Anyone else? Thank you. All right, in that case, the motion is to adopt Amendment 0180H to House Bill 337. And the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Bear.
Yes.
Representative Gerhard.
Yes.
The clerk votes yes. Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla.
Yes.
Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
Yes.
And we got 20 yea, 0 nay.
Okay. So Representative Schuett, you're moving up to pass with amendment?
And I'll second as well.
Okay. Is there any further discussion? I think we covered it already. In that case, the motion is ought to pass with amendment on House Bill 337, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
The clerk votes yes. Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla.
Yes.
Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
Yes.
And a vote 20 to 0. 20 yea, 0 nay.
All right. The vote is 20 to 0, so the motion passes. Any objections to consent?
Fiscal note.
Seeing none, we'll put it on consent.
It is a fiscal note, isn't it? So we don't,
The,
we're all
the
set. Okay,
amendment
thank you.
relates the expense, and I'm sure the committee report will make sure to say so. Okay. Speaking of that, committee reports are due today for anything that we can get in the calendar for next week. And I would appreciate if anyone that makes a motion gets their committee report in as quickly as possible. Excellent. I'd like to see somebody prepared. So yes, thank you. That's a good idea. Okay. Let's do something. On House Bill 449, Representative Goldie, I believe you have a motion.
Thank you, Madam Chair. I move to retain House Bill 449.
And I second. Do you wish to speak to your motion?
Sure. We have another bill that'll be coming before this committee dealing with this issue, and that being House Bill 436 that has an amendment that subcommittee will be hearing. I think that takes care of the issue we're looking at, so therefore, until that bill goes forward and is taken care of, that I think to retain it is the appropriate thing to do.
Yes, thank you. It'll be good to have something in case the Senate makes major changes to our bills or something like that. So, okay, any further discussion? All right, seeing none, the motion is to retain House Bill 449. The clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
The clerk votes yes. Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien,
Yes.
Representative Massimilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Yes.
Representative Susie, and the chair.
Yes.
20 yea, 0 nay.
All right, thank you. And Representative Goldie, you are fortunate. No report is needed on a routine recommendation. So that leads us to House Bill 436.
Thank you, Madam Chair. We received late yesterday an amendment that Representative Pearson has put a lot of work into. It completely overhauls 436 as it stands, and we need an extra day of subcommittee work to look at that. We'll bring it back to you next week.
Okay, if you wish to have your subcommittee on Friday morning, we can have the exec session Friday afternoon or next Wednesday.
I'll check with my subcommittee members and
Okay.
see what their
We-
availability is.
We need, it's an important bill and we need to get to work on it. So we will recess the exec session until either Friday or
Yeah, my only concern with Fridays, I know people wanted some time to look at it, and it's a fairly substantial amendment.
Well, we'll decide by the end of the day today when we will do that. It will be no later than next Wednesday, because that is absolutely, positively the last minute. Okay. That's that one.
Do we know whether Representative Pearson is going to be able to facilitate that? Would you
I
care to
believe we
share
do.
that with us, Representative?
Friday morning or Wednesday morning of next week.
No. No, when the subcommittee can meet is the question. Wednesday, unfortunately, we do have we do have scheduled public hearings, so you would want to have it ready to exec on Wednesday.
Is it possible for the subcommittee to meet after this exec session? Since
The
they
subcommittee can meet after this,
24-hour notice?
does a continuance of a work session require notice? Since it was
24 hours, yes.
it does.
Right. And this is not a work session.
I'm sure you can find a room on Monday or Tuesday if you need to, and like I said, Friday morning is available. I know for sure that rooms are available because no other committee is meeting on Friday. So you can have a room all day. Okay. All right, then. House Bill 250. Representative Simon.
Thank you, Madam Chair. I will move ITL on HB 250.
Is there a second? Fitzpatrick, okay. Do you wish to speak to your motion?
Yes. My apologies to the committee. This actually came out of the subcommittee, ought to pass 3-2. I was the deciding vote on that. Since that time, I've gained a better understanding of the bill. I missed the original public hearing. My understanding right now is that if an officer or anybody in Group 2 dies, they receive 50% of a year's salary, $100,000 out of the general fund, and they're still have their regular retirement package accessible as it always would. Obviously, we can't put a monetary value on somebody giving their life, and I wouldn't even pretend to try to do that. Our gratitude goes out to those people. But we do have to make decisions, practical decisions as well, and I feel like that's we are honoring them with the package that we're offering.
Representative Patrick? Do you wish to speak to your second? True. Oh, excuse me, gentlemen, my mistake. Forgive me.
I have nothing to add to the comments already made.
Representative Broda.
So I just want the community to know that this only is I will not support the motion of ITL, and I will say that this only people who pass away only get paid if they die. So let's hope that doesn't happen.
Yes, Representative Goley.
Thank you, Madam Chair. And I too will be voting against this. I think we heard testimony that if someone retires and chooses a benefit that allows their surviving spouse to get 100%, that option is available. So once that person passes away and dies, that the spouse continues to receive 100%. This goes backwards and says that if someone is killed in the line of duty, the spouse only receives 50% of that benefit versus the 100%. So I think it was a matter of fairness that we heard, and it codifies a statute that allows the 100% going forward upon the accidental death while in duty of service. So I cannot support the ITL.
Representative Lekis and then O'Brien.
Yeah, I had some initial confusion about that. My understanding, and if it's incorrect and the chair wants to ask Mr. Carlin to make it clear, we can do that. But I believe that those are two completely different things, that this bill is raising the 1 year amount they get if they die from 50% to 100 with on top of the 100,000 that's there. But if they're retired, they can get 100%, but that's a selection by the person who retired, and they're paying for that by accepting lower pension payments. At least that's my understanding. So I initially had similar thoughts as to what Representative Goley said, but I don't think that's how it works.
We're talking about 50% or 100% of two different numbers. This would raise the total value of this would make the amount that the widow would receive to be up from 50 to 100% of their annual rate of earnable compensation, which is not the same as the amount of pension that would have been earned. That's what it says, 100% of the manual rate of earnable compensation. Is that not correct, Representative Goley?
It's the state annuity, so it's the full term of the payment going out.
Right.
So it's 100% going forward.
Right.
Same thing that if a member chose the 100% option upon retirement at their death, that their spouse receives 100%.
Except that if the member chooses the 100% option, which many do, the amount they get is not the same as their annual compensation. It's the amount of their pension lowered to make it for 2 lives instead of 1. Mr. Carlin, if you could help us with our terminology here.
Thank you, Madam Chair.
I'm getting confused, and I'm sure I'm not the only one.
Thank you, Madam Chair. For the record, Marty Carlin from New Hampshire Retirement System. So the question is, what the current accidental death benefit for a Group 2 member who is killed in a job-related incident, the surviving spouse would get 50% for life of the member's last year of earnable compensation. So whatever their current rate of earnings were, 50% of that as a lifetime benefit, plus a refund of the members' accumulated contributions towards towards their own retirement. The money that they were putting in over the years before the incident. So that this bill would increase that to 100% of the last year's earnable compensation, and the lump sum piece stays in there as a payout. The $100,000 death benefit you reference is a separate appropriation outside the retirement system. That's a general fund provision.
Okay. But at retirement, if the member were to select the 100% option, just for simplicity's sake, the amount that he got would not be necessarily equal to his last year's earnable compensation. Is that correct?
Correct. I mean, if the last year was in the high 3 or the high 5, it would be, a portion of that. But, when a benefit is calculated, there's what's called the maximum option, which is the benefit is paid to the retiree for their lifetime. And as discussed, there's something called the survivorship option, where the member can make a choice at retirement to leave some or all of their pension to one or more individuals. There's some statutory limitations on who you can give that to. And if you're leaving a survivorship option, there is a reduction in the monthly benefit from the outset related to the basically it's based on the age of the member and the age of the beneficiary. It's sort of a life expectancy calculation.
Okay. So that the fact that this benefit is 100% of or 50% of earnable compensation is not necessarily related to what the pension would be, even at 100% survivor benefit.
Correct. There's a little bit of a variation in the statute. The Group 1 accidental death benefit is 50% of their average final compensation. The Group 2 is 50% of their, current, annual rate of compensation. I'm not sure how much more different that is for some people, but, it is set up differently in the statute already. I'm not sure what the history on that is.
Okay. So that the maximum pension would be 50% of earnable compensation for last 3 years or whatever, and that would be reduced to allow for it to continue over the spouse's life as well as, or the beneficiary's life as well as the.
With the service retirement, yeah.
Yes.
Yeah.
Okay. Thank you.
There's no age-based reductions or anything in the death benefit
Okay,
pieces.
thank you. Representative O'Brien, you had a question?
Thank you, Madam Chair. Judging by your questions, first, I'm not going to support this, obviously, but I do agree with Representative Gooley and what he said. But it seems to be the focus in the questions is at the end of the career. I'm more concerned at the beginning of the career. We were all young men, all young ladies once, and we know our financial obligations at that particular time. We were in a very critical moment. We went out and purchased houses, cars, different things, and we're blessed with children along the way and had those other expenses that came up. But most of your contractual stipulations and departments, you work in a tiered environment. For every single year, you come on at probationary rate of pay, like I say, and then you work yourself up to basically top step. So if you were a firefighter on probation, married with children, and were killed in the line of duty, you're talking a mere pittance with this. And that's going to put that family into a financial strain. And this is the reason why this bill came forward. It's talking about, fortunately, a very rare event that occurs. Okay, it's not like we lose a firefighter a month or a police officer a month. If you did, who would want to work those jobs? It's very difficult. So in the rare cases that it does happen, it protects at all. Yes, it will protect the guy that's at the high end, closer to retirement. But don't forget about the young guy that is trying to start the family. He's at the weakest financially at that particular time and needs our protection. So I am not going to support this bill. Thank you, Madam Chair. And may I have a question of the chair, please?
Sure.
It seems with additional information, do you think we would want more time to digest Mr. Collins' remarks, or do you want to have the vote stand?
Well, there's a couple of people that have already signed up to speak, so we'll let them talk.
Okay, thank you, Madam Chair.
If there's a consensus to pause on this, we can do that. Representative Hebert.
Thank you, Madam Chair. It would be my sentiment to have a little bit more time on this based on the confusion among the committee and my own confusion. Thank you.
All right, thank you. Representative Schuett.
Thank you, Madam Chair. I don't know if he knows the answer to this, but I'm curious if Mr. Carlin could give us an idea of approximately how often this kind of thing happens on the job.
I can, if I went back to my chair and looked on my phone, I could find out exactly in a couple of minutes. And I will do that after I leave this seat and wave my hands if I'm wrong. But I believe there's currently about somewhere in the vicinity of 20 Group 2 job-related death benefits being currently paid to survivors at this point. I think it's 19 or 20 or something like that. But if I'm way off, I'll wave my arms. But I'm pretty sure that's what the current landscape is.
This would not be retroactive, though.
No,
Those
no.
people. My question is if you have a sense, and I know it's not totally accurate, how often we lose one of these people on the job.
I don't have a strong sense. I mean, typically when a tragedy like that happens, it does get news coverage, and I can certainly recall, more than a couple in recent years, but I don't have a count. Maybe, somebody else with one of the member organizations has a better idea of the incidence of this, but it happens, sadly.
But rarely, yes. Representative Abear?
Thank you, Madam Chair. May I suggest on all future retirement bills that there be a graph that's not like the graphs that we get?
Perhaps you should talk to the retirement system. Mr. Carlin is the person involved.
Thank you. May I talk
Yeah.
directly to Marty?
Yes.
Marty,
Not
going
the mo-
forward.
Not right now,
Oh,
please.
sorry.
Yes, I can express your frustration with some of the data information we get. It's not always the best. Mr. Whithu, I'd like to say this is not a public hearing. We are not taking testimony from the committee, from the public. It is purely a discussion in the committee to vote on the bills. We might ask, as in this case, someone that has special knowledge, but we are not taking testimony. The public hearing was a while ago on House Bill 180. All right. Any other questions, Representative Simon?
Thank you, Madam Chair. I'm in a bit of an awkward quandary at the moment because after Mr. Carlin's testimony, this is closer to what I thought it was initially than what I was led to believe secondarily. So I don't really support my own motion.
Well, that's a very awkward situation.
It's an
to
awkward
be in.
situation for me to be in.
Perhaps
I
you
just
should withdraw
Offer
your motion.
accepted.
if I'm allowed to withdraw my motion, I would like to do
Yes,
so.
withdraw your motion, and I think we will meditate on this for a few minutes and go on to the next bill. This,
Offer accepted.
what's that?
Offer accepted.
Okay, thank you. All right. Okay, so House Bill 371. Well, no, let's finish the retirement. House Bill 571. Representative Simon, do you have a motion on that?
Yes, I move in expedient to legislate, Madam Chair.
Okay. Is there a second? Is there a second on ITL 4?
Second?
Okay. Do you care to speak to your motion?
Yes, Madam Chair, thank you. As I stated in the subcommittee, this year 436 has got to be our main priority and focus, and it's going to be quite expensive. A lot of people are finding themselves, whether they're in Group 2 or not, they're finding themselves in precarious situations financially due to inflation. And I don't want to force people who are not in Group 2, who are in precarious situations, to pay extra taxes for this at this particular point in time. So for those reasons, I move in expedient to legislate.
All right. Would you like to speak to your second? Oh.
Yeah, no further comment. Thank you.
What?
I don't, everything you said was great.
Okay. All right. Does anyone else wish to speak? Representative Abear and then Goley.
Thank you. I support this motion, but I want to make it clear why I do. That I truly believe that 436 needs a lot of work, as Representative Simon indicated, and that I am hesitant to push through too much and have us lose everything. We know how contentious this has been year over year over year. And I think our focus needs to be on 436. It is not my intention to put retired firefighters and police over active firefighters and police. That is not what this is about. Thank you.
Okay, other Representative Goley?
Thank you, Madam Chair. Now let me try and win over Representative Simon one more time. No, to be honest, I cannot support the ITL motion. We are a policy committee, not a money committee. That is to be done in finance. And I think the true policy here is whether or not those retirees deserve a cost of living adjustment. We have to remember Group 2 members do not pay into Social Security. While that is for the jobs they're working as police, fire, or corrections, some may have a side job and pay Social Security on the other end. But when they go to collect that Social Security, they're getting it at probably 70% of what they're entitled to because of what is called a windfall that doesn't allow them to collect the full amount of Social Security they pay into. Group 1 members pay both Social Security and retirement. They're able to collect on the cost of living adjustments that were just handed out this year by the federal government. And Group 2 employees don't see that. So to stay up with the economy, and as we all see cost of living increases in our food, heating oil, gas prices, I look at this as going forward a policy issue that this committee needs to address. How it's funded or whether it's funded, I believe belongs in finance. So I'm not going to support the ITL. Thank you.
Thank you. Representative O'Brien, and then, no, O'Brien.
Okay, thank you, Madam Chair. I am not going to support this, yet I agree totally to what Representative Goley has said. But to come up with his own, when I sit in this chair, I try to judge as best as I possibly can without fear and favor and not intimidated by any other committee. That is not up to me to judge that, what another committee is going to do. When, as you know, as representatives, when we write a bill, we hand the bill over to the committee. It's no longer our bill. It becomes the property of that committee, and they make that particular decision on what they want to adjudicate as far as their decision. We are a policy committee, okay? And with deep respect to Representative Simon, I understand sometimes you can go to the well too much and engorge yourself with water. You can ask too many times. It's a well thought idea. But then that's ruling by fear and favor, because what would happen is, all it seems in the past, and I'm not pointing any blames, but this particular group has been a lot of mileage in years since the last time they received a cost of living increase. If the time isn't right now, then I got to ask you the proverbial question. Is next year correct? Or the year after? When are we going to, find out when the proper time is going to be? So the thing is, this is why we have our form of government. We're the policy committee. We should push this forward to the next committee, which would be finance, and allow them to determine if they can afford this. If they cannot, we're right back to where we are in the position of ITL. My recommendation is that to change the vote and go for ought to pass to assist the people who dedicated their lives to their own respective communities many years ago. So, thank you, Madam Chair.
Representative Gerhardt, and then Simon.
Thank you, Madam Chair. And thank you, Representative O'Brien, for that testimony. I'd like to take a different tact on this. My concern is that we're both what we're doing if we go forward with this and just OTP it, we're pitting one group of seniors against another group. So in my town, Northfield, there's 65, I believe it was, seniors that are applying for property tax exemptions or waivers for the interest fees because they can't pay their property taxes. And I'm just worrying that by benefiting this group, now we're going to be putting them in danger of losing their homes. So my whole issue is inflation's coming from the federal government. Why aren't we dealing with that at that level? And I believe there's mechanisms that we can do. So for instance, there's $1 per pack. It's actually 101 per pack of cigarettes. There has to be some mechanism where we can say, okay, you know what? We're tired of sending you money because obviously you're just deflating our currency as it is. That's my whole position on that. I'm just worried about pitting one group against another group when our real problem is who is printing the money like it's going out of style.
Thank you. And Madam Chair, this is not going to be a debate. I respect the gentleman's point of view. But from my experience as Vice President on the Board of Aldermen, we do give out elderly exemptions, okay? But that liability, that isn't a gift from City Hall. That is met by somebody else. And in this particular case, yes, it would be met. But the thing is, this is people. If I had my most idyllic world, and fortunately you're a young fella, you're not ready to cross that elderly bridge yet, and God bless you for that. But the point I'm trying to make, as you get older, your spending power or receivables decreases. Okay, and if you're on a defined benefit program such as this, which most of the firefighters and Group 2 employees do not get to Social Security, so they're not getting the bump up at that particular time. So they're frozen in time. You might as well cake them in ice. Okay, and they are going to be the problem in the community. Because what's going to happen at some point without a COLA, they're going to become less means to be able to afford their housing. They may be kicked out of their particular housing, might be defaults. Worst case scenarios can happen when you have no other means of income. Are you going to tell an 80-year-old guy to go out and get a paper rope? I choose not to.
Thank you,
So,
Representative
thank you.
O'Brien, for presenting a very extreme position. Representative Simon.
Thank you, Madam Chair. And Representative O'Brien, the respect is absolutely mutual. I just want to clarify, I'm not making an argument simply based off of money and whether or not we should be spending the $82 or $84 million that this bill is asking us to spend. My contention with it is that when the members of Group 2 agreed to their defined benefits package, they were agreeing to a package, and that package did not include a yearly COLA. It didn't agree to a COLA at any point in the future. So from my perspective, this is a policy decision in which I fully sympathetic to the difficult situations that we all find ourselves in as we get older. Group 2 members are no different than that, but neither are any other citizen in the state. And because the benefit package did not include a COLA, I don't feel that we're under obligation to favor them, because at that point we are. It wasn't in their benefits package. We're favoring them over other people, and those other people are the ones who are going to be footing the bill for this. So all of the examples that you just gave in your testimony can be applied to people outside of Group 2. And once again, furthermore, because of the way that we fund this, those other people who can find themselves in the same situation are then going to be taxed more in order to pay for this benefit. And so it's not in my perspective, that is a policy issue. I am making that determination on a policy issue, and that's the primary reason why I'm moving ITL. I could stomach the 84 million if if it was a good enough reason. It's the policy thing that's got me concerned.
Okay. Representative Goley.
Thank you, Madam Chair. And just to address the cost of living adjustment, Marty, correct me if I'm wrong, was there not a supplemental account that provided some COLAs previously in the retirement system, or what's the history
I
of that?
can answer
if we
that
could?
question. There was a COLA. There was a special account that funded cost of living increases, but the money that went into it was only made available by inaccurate and, in hindsight, foolish actuarial assumptions.
If I may respond, but there was COLAs being provided, which we just heard there were not, and when the people signed up, but there were COLAs that were provided.
Yes. There have been cost of living increases granted periodically since the retirement system was founded. Absolutely right. Anyone? I would like to comment that I think the approach to this bill by specifying only Group 2 members is divisive and somewhat discriminatory. And I understand why you did it, because it is, somewhat a supplement to Social Security. But I think that the approach is bad policy, in my opinion. So I'm going to be supporting the motion. Anyone else? Yes, Representative O'Brien.
You tweaked my melon that I got for that I was born with. If Madam Chair, if you feel that way, are you in essence saying that maybe we're going around this the wrong way, and maybe this bill could be held and work for further amendments? That you feel that any way to go? Because we are talking about a very, very important issue in supplementing the income of some of our less fortunate, who only sin is Father Time.
Yes. Well, I wouldn't say that that's their only sin. I'm old. I'm retired, and I know that when I was working, I had a defined benefit pension, and I looked at it and said, I'm not going to be able to live on this. And so I took steps to make sure I had other funds available. And I would not insult the intelligence of our police and firefighters to say that they couldn't have realized that themselves and taken similar steps. And the same for our Group 1 employees. I mean, we all of us retirees were working in the late 70s and early 80s when inflation was rampant. We know that it can happen. So if we didn't take steps, we are gambling on the charity and the mercy of the legislature to give us money and to charge our friends and neighbors for it. That's my position on the policy.
Follow up?
Follow up.
That's your position. So there's no saving of this that you can see?
We'll see what the committee decides. I'm not the only one with a position.
Thank you, Madam Chair.
All right. Anyone else? Representative Dolan.
Yes, thank you, Madam Chair. I just would encourage you to move the question.
What's that?
I would just encourage you to take
We-
a vote.
Thank you. We can't do that in committee. Debate in committee, executive session cannot be cut short for any reason. Except, of course, lack of interest by the other members when they, that's the only reason. All right? Anyone else? Representative Hebert.
So could I just get clarification before the vote? Was there a COLA and then there wasn't a COLA and now we're trying to put a COLA back in?
No. Ever since the retirement system started, there have been various increases given in pensions, sometimes one-time payments, sometimes complete COLAs. They were always ad hoc and at the will of the legislature. They are not in the plan. There's no money saved up for them, and they are not guaranteed. So there have been many cases in the past where COLAs were given. But again, they're not in the plan. Representative Schuett?
Thank you. Possible clarification of Representative Abar's question. The last term, there was a one-time payment that was made to retirees, but it was only to those who made $30,000 or less. In most cases, Group 2 retirements are slightly more than that. However, so they were not included because it was capped at that amount, and it was a one-time only payment. And most of the Group 2 retirees probably make around $40,000, maybe $50,000 in retirement, but don't get anything added to that in the way of Social Security. Bear that in mind. So they were basically excluded from that one-time payment. Thank you, Madam Chair.
Yes, that is correct. Anyone else? Okay, in that case, the motion is inexpedient to legislate by Representative Simon, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo-Nastaso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Weber.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Groda.
No.
Representative Schmidt.
No.
Representative Schuett.
No.
Representative O'Brien.
No.
Representative Massimilla. Representative Davis.
No.
Representative Fitzpatrick.
No.
Representative Gould.
No.
Representative Susie. And the chair.
Yes.
We got 10 yay, 10 nay.
The motion fails on a tie.
Madam Chair,
Yes.
move ought to pass on House Bill 571.
All right, ought to pass by Representative Goldie. Is there a second?
I'll second.
Goldie, seconded by Representative Groda. Do you wish to speak to your motion?
I think I've said enough. It's just a matter of, this has been given in the past, and these folks do not receive cost of living adjustments through Social Security, and I'll leave it at that.
Okay, Representative Groda?
No. No comments. Thank you.
All right, does anyone else wish to speak? All right, in that case, the clerk can call the roll.
Representative Simon.
No.
Representative Lakis.
No.
Representative Bailey.
No.
Representative Santo-Nastaso.
No.
Representative True.
No.
Representative Dolan.
No.
Representative Weber.
No.
Representative Gerhard.
No.
The clerk votes no. Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
No. All right, that motion fails on a 10-10 tie, unless I've counted wrong.
Yes. 10
Okay.
10.
Therefore, we will send this to the House with no recommendation. Representative Simon, you will write the statement in favor of ITL, and Representative Goley in favor of ought to pass. And we can do that today, that we can have an interesting debate next week. Okay, that's no recommendation. All right, moving away from pensions for a moment. House Bill 341, establishing licensure from established establishments. Representative Santo-Nastaso.
Make a motion ITL for 341.
Is there a second?
I'll.
Okay. I do wish to speak to your motion.
Yes. 341. It looks like the intent to establish licensing for massages is to prevent sex trafficking, and I don't believe that this is gonna solve the problem. It's kind of we already have like law enforcement to look into these things and produce warrants to enter establishments, and the misdemeanor for not registering is that's not going to be enough incentive for people to either just continue doing it without a license. They're not going to comply with this if they are actually doing having a sex trafficking operation. And they're not going to go ahead and get licensed so business can be looked into. So I don't think it's going to help.
Right, Representative Gerhard.
Thank you, Madam Chair. Going back to the original testimony on this bill, there was a massage masseuse who submitted testimony that she contacted police for propositions of performing services that were extracurricular in the field, and the police weren't interested, as well as the fact that local police, we were told, were not enforcing ordinances. They just didn't feel it was priority. So if local entities are not concerned with this, I don't see the point in having the state step in. Thank you.
Thank you. Representative Groder.
Excuse me, I'll be voting against the ITL motion. In testimony, the bill was brought forth because other businesses are also licensed, such as the Pharmaceutical Board and other similar boards. And this is not a law enforcement proposition. This is a public safety bill. And lastly, I do have an amendment to House Bill 341, which I can introduce at a later time. So I'll be voting against the ITL motion.
Thank you. I'd like to comment that a substantial portion of the regulated community was opposed to the bill, which is generally a red flag for imposing a new license. They may have been organized by a group outside the state, Representative Schmidt, but they are in fact New Hampshire businesses, and they are working here. They're licensed by the Board of Massage Therapists, and they don't want to have this additional license imposed on them. So I'm very much concerned that we are putting restrictions on our small businesses in order to make it easier for law enforcement to target some of the bigger ones that are the bad apples. And that's something that I don't think is right. I'm also very concerned that we're willing to use our licensing organization as law enforcement. I can't imagine getting your license, somebody from the OPLC saying, "Hi, I'm here from the OPLC. Please show me your licenses," into a sex trafficking operation. I mean, that's a very unsafe position to put those people into. Representative Dolan?
Thank you, Madam Chair. I'll be voting in favor of the ITL. But I am concerned that the state is not doing enough to stop human trafficking.
Okay, thank you. Other comments? Representative Bailey?
I think there's been some kind of mistake. I mean, this is not a licensing function. This is some kind of law enforcement function. And if you have any doubt of that, there was a parade of police officers all the way up to Homeland Security testifying in favor of this, and not a single masseuse or massage parlor and proprietor or, with apologies to Sherlock Holmes, it's not the function of licensing to supply the deficiencies of the official police. Thank you.
Okay. Anyone else? Representative Schmidt?
Well, we're capitulating in the face of a clear public nuisance, a public anti-safety situation. When we had people from one of the towns that indicated that they were having a major problem with this, and there are something like 35 or 40 of these establishments. So if you're going to talk about law enforcement, the reality is it's only a misdemeanor. And so it really isn't worth the police's time to bounce somebody who they get their fine paid, they get shipped out of town, they get replaced immediately. The operation goes on and the police feel completely frustrated in their inability to have a positive impact on this. And so to the degree that the legitimate therapeutic massage practitioners are in some cases even being conflated with these illegal sex traffickers is something that was used to, in my opinion, improperly influence the people we heard from, a very small number of people, by the way, the practitioners. So if we are going to do nothing, then we might as well go home. But I ain't going home. I'm voting against this, and I'm going to continue to try to get us to do something responsible for the communities that are being plagued. Derry, 4 or 5 of these places, Merrimack, 4 or 5 of these places, for a total of about 40 in the state of New Hampshire, and we are doing nothing, but we could be doing something.
Perhaps we should be making it more than just a misdemeanor so that the local police are incentivized to take stronger action. Would Representative Gould and then Simon?
Thank you, Madam Chair. I don't see this, I mean, I hear the testimony breaking down on the bipartisan lines. And for me, it's very important to take a look at who it is the policy should be helping. And I did not hear from hardly the few massage parlor therapists I heard from were opposed to it. And so, though it may be very unpopular, I am going to vote to support the ITL.
Thank you. Representative Simon?
Thank you, Madam Chair. I would just like to say, I don't think that this is an issue of us capitulating. I hate human trafficking. I hate sexual human trafficking. I am more than happy to fight on every reasonable front to stop that practice from happening. But I think we should be honest about what we're doing. And OPLC has a lot of inspectors in a lot of different areas. They go in to make their inspections for a reason and a purpose, and that is so that the public is safe, specifically regarding the service that they're providing. And I don't really want OPLC investigators coming into my business as a convenience store deli looking for money laundering. I feel like that is a law enforcement issue. I don't think OPLC is, because they're not law enforcement, I don't think they're in a position to do that safely. That is not their area of expertise. If we can come up with another solution to this that does go primarily in the law enforcement direction, misdemeanor, in my opinion, is ridiculous, and that needs to be adjusted. I'm happy to work on that. I'd be happy to be a prime sponsor on a bill like that. But I think that this approach is dishonest. I think it muddies the water too much, and I think it puts people at risk that shouldn't be at risk in order to solve this problem.
Representative Groda?
There's no dishonesty in this bill, and there's no dishonest intent, and I am offended by that. This bill is a licensing bill for public safety, and it allows the inspection of massage establishments just like we allow inspections of hairdressers, cosmetologists, estheticians, anybody who is serving the public. So please, let's stick to the subject.
Yes.
Thank you.
Thank you, Representative Broda. You can't know why someone is doing something, and it is thoroughly improper to attack their motives. The effects, yes, but not their motives. So,
If I may, I had no intention of doing that, and I didn't even realize that I had. So I sincerely apologize. That's not the way that I meant for it to come across, Representative.
thank you. Any other comments, questions? Yes, Matt, Representative Gould.
I just want to follow up that I really appreciate the intent of Representative Grody on this bill and others that worked really, really hard on it. And I support 100% that the bill got hijacked by this whole sex trafficking. And what I found particularly offensive was the whole issue became focused on one minority group. And we know that who work in the field that the problem is much bigger. So I support Representative Grody's efforts, but the way the bill got presented in the hearing, I cannot support it.
Thank you. Anyone else? Okay. Seeing none, the motion is inexpedient to legislate on House Bill 341 by Representative Santonastasso, and the clerk can call the roll.
Representative Simon?
Yes.
Representative Lakis?
Yes.
Representative Bailey?
Yes.
Representative Santonastasso?
Yes.
Representative True?
Yes.
Representative Dolan?
Yes.
Representative Weber?
Yes.
Representative Gerhard?
Yes.
Clerk votes yes. Representative Groda?
No.
Representative Schmidt?
No.
Representative Goley,
No.
Representative Schuett,
No.
Representative O'Brien,
No.
Representative Massimilla, Representative Davis,
No.
Representative Fitzpatrick,
No.
Representative Gould,
Yes.
Representative Susie, and the chair.
Yes.
And get a vote 11 yay, 9 nay.
Okay, the motion passes 11-9. I don't believe we should go for consent. Representative Grota, do you wish to write a minority report? Yes, okay, so Grota will write a minority report. Okay, that's that one. All right. House Bill 620. Representative Sirwa, you had a motion?
Actually, no.
Representative Lekis has a motion.
Yes, I'd like to move ITL on HB 620.
Is there a second?
Second.
Okay. Do you wish to speak to your motion?
I do. First of all, from the EDNA point of view, I think the idea of standing up a whole separate department for the purpose of basically a pilot program is a very strange, odd, and inappropriate one. And I've heard there's some discussion about maybe amending it to change that, maybe put it into the DOE or somewhere else. And my issue with that is, I mean, the question of whether or not that's a good idea is not one that I think is appropriate for EDNA. I mean, that's an education question, and that should go to that committee. And if people want to do that, there could be a bill that would address that separately without trying to stand up a whole department just for that. And on a somewhat not serious note, I wouldn't want to step on my wife's feet, her toes, on taking over education bills. Anyway, thank you.
Representative Santos Stasso, do you wish to speak to your second?
I concur with Tony Lekis' comments.
Okay. Representative Broda.
Thank you. So there was a subcommittee meeting on House Bill 620, and the Department of Education attended the subcommittee meeting, and there were 3 subcommittee members there, myself, Representative Wilhelm, and Representative Santonastaso. And an amendment was discussed because the Department of Education does want this under their jurisdiction. And the amendment was written so that the Department of Education would establish a division, not have a separate department. Therefore, I would encourage the committee, we can do 2 things. We can continue, obviously, on the vote, but I also would like to suggest that the subcommittee, which did not look at this amendment and could meet again with all its members present, could take a look at it and comment on the amendment to the committee. Thank you. But I will not support an ITL motion.
Thank you. Comments? Questions? I'd like to say myself that I attended part of that subcommittee meeting, and it seemed to me that that there wasn't much of a need for a bill. At the hearing, the Board of Education from Manchester spoke in favor of this, but they already have a pilot program very similar, as far as I could tell, to what this bill would create. And so I don't see the need for us to get involved. And I'm also very much against forming a new division or a department for something that I'm not convinced is actually a state responsibility. So that's my position. Representative Hebert and then Grota.
Thank you, Madam Chair. I will be supporting ITL against HB 620 FN for the one fact that during testimony, what we heard is ARPA funds were used to establish this pilot in Manchester. And I ran on lower taxes and don't believe that anything with any ARPA fund should be a one-time thing and done. And this is growth of the education department. So I am voting ITL. Thank you.
Okay. Representative Groder? Anyone else?
I was going to ask it,
Okay, if you don't wish to say anything, then the motion is inexpedient to legislate by Representative Blackus, and the clerk can call the roll.
Representative Simon,
Yes.
Representative Lakis,
Yes.
Representative Bailey,
Yes.
Representative Santonastasso,
Yes.
Representative True,
Yes.
Representative Dolan,
Yes.
Representative Weber,
Yes.
Representative Gerhard.
Yes.
The clerk votes yes. Representative Groda,
No.
Representative Schmidt,
No.
Representative Goley,
No.
Representative Schuett,
No.
Representative O'Brien,
No.
Representative Massimillo, Representative Davis,
No.
Representative Fitzpatrick,
No.
Representative Gould,
No.
Representative Susie, and the chair.
Yes.
And we got 10 yea, 0 nay.
No, 10 and 10.
10, I'm sorry, 10 and 10, I'm sorry.
It's quite all right.
I'm a little flustered.
All
with
right, the
those ones.
motion fails on a tie. Representative Groder, you have another motion?
I do. I move amendment number 2023-0376, and I can distribute that to the committee now. And the bill,
Do we have copies of that amendment?
right here.
Okay, if you could pass that around.
Yep.
And meanwhile, does someone wish to second the motion? Okay, thank you. And thank you.
So the amendment creates a division. This amendment was written in conjunction with a representative from the Department of Education during the subcommittee meeting, and Representative Heath, the bill sponsor, was also there. And this bill creates a division of early education in the Department of Education, and it's whether or not we all think of when education starts. Does it start pre-K, or does it start when you're in kindergarten? Does it start when you're in first grade? When do you think children should begin their formal education? It's a pilot program, so it's not something that it does have a restrictions on that, and it does give the financial responsibility for the program to the Department of Education. So they're the ones that will decide how to fund it and how to implement it. It gives them the authority to do so. So what we're saying is that we're going to amend the bill so that it gives the responsibility of creating this pilot program to the Department of Education with their rules that they think should be applied to the program.
Thank you. Representative Gould, do you wish to speak to your second?
No, I think Representative Grody said it all.
Okay. Any comments, Representative Blackus?
And actually, I'll answer the good question that was posed, which is I do not believe that formal education should start as early as pre-K. So on the policy point of view, I don't agree with the bill.
I'd like to
Thank
say
you.
something.
Yes, Representative Fairley.
So here's my stance on this. I would never support this bill whatsoever until we could actually get a handle on the indoctrination that's going on in our schools, and it is going on in our schools because I've been speaking with the teachers and the parents, and they all agree that this is getting out of control. So until we could get a handle on that, I would never vote for this bill. Thank you.
Okay. Other, Representative Gerhard.
I would just say that in general, from what I've seen, at least in my district, the public school, the proficiency rates are just really, really bad. And I just don't think adding more to their plate at this time is the right way to go.
Thank you. Anyone else? Representative Weber.
just one more comment. During testimony, it was made clear that the parents would be involved in these 3 and 4-year-olds, 3 years old sitting in front of a computer, trying to learn. I think that we've all heard what a disaster remote learning during COVID was. So that's also why I will vote ITL. Thank you, Madam.
Representative Dolan.
Thank you, Madam Chair. My colleague raised a key point that concerns me, that if the availability of funds for this program was a one-time insertion into the budget, yet this bill would make the expenditure of those funds a permanent, recurring event. To me, that's a disconnect. That's hits under the funding side, and quite frankly, could be a violation of our Constitution as an unfunded mandate if you look beyond year 1.
Thank you. Anyone else? Representative True.
Thank you, Madam Chair. And a question of the chair. Is there an end to the pilot program that I missed?
Line 21 says it's 3-year,
Thank you, Madam Chair.
but there's nothing so permanent as a temporary government program. Okay. Anyone else? Representative Goley.
Thank you, Madam Chair. Just a quick question for Representative Grody. You did say the Commissioner of Education was before the subcommittee and supported this?
The Deputy Commissioner of Education was here before subcommittee to represent him and herself in supporting this program.
Any other comments, questions? All right. In that case, the motion is to adopt Amendment 0376H to House Bill 620. The clerk can call the roll.
Representative Simon.
No.
Representative Lakes.
No.
Representative Bailey.
No.
Representative Santonastasso.
No.
Representative True.
No.
Representative Dolan.
No.
Representative Weber.
No.
Representative Gerhard.
No.
The clerk votes no. Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie.
Yes.
10 yay, 10 nay.
Excuse me.
Oh, I'm sorry. And the chair.
I'm going to vote yes because I think the amendment improves the bill drastically.
Okay, I stand corrected. 11 yes, 9 nay.
All right, so we have adopted the motion, the amendment. Representative Groder.
Yes, I have a motion of auto pass with amendment, OTPA, on House Bill 620 with amendment 376.
Is there a second?
Second.
Representative Goldie, okay. Any further discussion? I will say that I voted in favor of the amendment because it eliminates the department, which I was strongly opposed to. But I'm still going to vote against ought to pass with amendment because I don't think we should be getting involved in pre-K education as a government. Certainly not at the state level. Anyone else? Okay. Seeing none, the motion is ought to pass with amendment on House Bill 620. And the clerk can call the roll.
Representative Simon.
No.
Representative Lakes.
No.
Representative Bailey.
No.
Representative Santonastasso.
No.
Representative True.
No.
Representative Dolan.
No.
Representative Weber.
No.
Representative Gerhard.
No.
The clerk votes no. Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien,
Yes.
Representative Massimilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Yes.
Representative Susie, and the chair.
No.
We have a vote 10 yay, 10 nay.
All right. This is another one that will be going to the floor with no recommendation. Representative Lekis, you'll write the report in favor of ought to pass, and Representative Groda that in favor of of ITL, excuse me. And Representative Groda will write the report ought to pass with amendment, correct? Okay. All right. Well, let's go to something a little lighter. House Bill 183. Representative Goldie, you had a motion.
Move to retain. House Bill 183.
Okay,
I'll second.
Okay, seconded by Representative Simon. Do you wish to speak to your motion?
Sure. I think, I mean, we heard the breakdown was basically 75-25 on retired versus firefighters who are employed working at the academy. But in watching the subcommittee and looking at the numbers coming out, we couldn't get a real handle on the actual numbers of retired firefighters and how many of those that are retired working at the academy would take advantage of increasing hours. I think it would be helpful if we had exact numbers, because if this is only going to benefit 4 or 5 individuals, passing legislation for a small group of people, I don't think is necessary. And I think until we have those actual numbers that we can work off of to see if this would work to get more people working over at the academy or not, we need those baseline. And so until we get that, moving retain.
Okay, Representative Simon?
Thank you, Madam Chair. There were a number of unanswered questions and a lot of information that we didn't have. If we were to pass this piece of legislation right now, it has the potential to affect other groups as well who may want to do the same thing. And I would like to have a better handle on what the ramifications of that would be. I also don't want to just kill it because I think it has merit and it's something that we need to be concerned about. So we'd like to look into it further.
All right. Anyone else? Okay, in that case, the motion is to retain House Bill 183, and the clerk can call the roll.
Representative Simon,
Yes.
Representative Lakis,
Yes.
Representative Bailey,
Yes.
Representative Santo-Nastasso,
Yes.
Representative True,
Yes.
Representative Dolan,
Yes.
Representative Hebert,
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Groda,
Yes.
Representative Schmidt,
Yes.
Representative Goley,
Yes.
Representative Schuett,
Yes.
Representative O'Brien,
Yes.
Representative Massimilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Yes.
Representative Susie, and the chair.
Yes.
20 yeas, 0 nay.
All right, and no report is needed, so we're in luck. House Bill 193, Representative Lakis.
I'd like to move, let me find it here, ought to pass with an amendment. And I will have that in a moment here.
All right, while you're getting the amendment, is there a second?
Second.
Second, thank you. I'm very disappointed. In previous years, the opportunity to show support without having to write a committee report usually got 12 seconds.
The amendment is 022H. And people recall this bill was cleaned up a number of sections in the language around the retirement system statutes. This was at the request of the retirement system. Some of them were where there were conflicting areas in the statute. There was a change in the name of one of the the standards boards that they're required to adhere to, and that had required changes in here. The amendment has to do with teacher job share, and I guess for teachers, there are situations where two of them share a job, and that was not, and originally the bill allowed for that, but only if they were on different days. And it turns out that some of them will do the morning, some in the afternoon, still split days. And then there was a further redo of the amendment that they're not always 50-50. So the amendment allows a little more variance than that. And it's, the amendment is okayed by the retirement system. It was actually at the request of the teachers union, so.
Okay. Representative Goldie, you wish to speak to your second?
No, I think it was explained very well.
Okay. Anyone else have comments, questions? Okay. The motion is to adopt Amendment 002H to House Bill 193. And the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Weber.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susi. And the chair.
Yes.
20 yeas, 0 nay.
All right, we have adopted the amendment. Representative Lekis, you move on to pass with amendment? Is there
I
a
do.
second?
Yeah, sorry.
I'll second.
Okay. Do you wish to speak any further?
I don't.
Representative Simon?
Representative Lakis is too good of a speaker to come after, so I'll pass.
Does anyone else wish to speak on House Bill 193? Questions, comments? All right. In that case, the motion is ought to pass with amendment 0022, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Weber.
Yes.
Representative Gerhard.
Yes.
The clerk votes yes. Representative Groda.
Yes.
Representative Schmidt.
Yes.
Representative Goldie.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susi. And the chair.
Yes.
20 yeas, 0 nay.
Madam Chair, I
Yes.
appear, I may be a good speaker, but I'm not as organized as I should be. I gave you the wrong amendment number. That was the earlier version. So can we reconsider or whatever the correct? Yeah.
I think that's an editorial correction, since we know that you meant the right amendment. What is the correct number?
0269H, and my apologies to the committee.
0269, and perhaps you have copies of that amendment?
Don't know.
But
if
don't
I
we
do.
all have to have a copy of the amendment to vote on it, or no?
It depends on how much you trust Representative Lekis.
Now I don't know how much to do. It is, the 0269H is as I described, and the difference between 22H and 0269H is the allowing for splits other than 50-50. It allows 50-50, 60-40, and 70-30, which the retirement system was all right with. They didn't want it to go further than that.
All right, I think we've been going at this I think we will take a short break and Representative Lekis will get copies of that amendment for all of us. And we will decide if we need to, whether that's what we thought we were voting on or not.
How short is the break?
10 minutes.
I'll run right up.
just splits it down to 70-30 at the max.
Yes, ma'am.
You asked for 25 copies of 391, which was Nancy Murphy's bill.
Yeah.
Did you pick them up?
No,
Okay, I'll go.
Representative person.
I don't think so.
Pleasure, sir.
391.
I can absolutely do this Friday.
Okay.
So
I'm just, my only concern is, I mean, I guess it doesn't matter all that much, just making sure that everybody is in support and doesn't have any problems with it. 'Cause
Well,
otherwise I'm gonna have to
that's
run and get
why you
amendments.
have to meet. That's why you
yeah,
have,
I mean, every
OLS will be
I'll set
there.
it- I'll set it for Friday.
Okay.
so you know, it's,
You're,
and it being
your mic's on.
For the committee, we have received a very nice thank you note from Heather. It's posted on the board. She thanks us for our farewell gift and invites us to stay in touch. So we will do so. And has everyone had a chance to look at Amendment 0269? I guess so. Okay. Is this what you thought you were voting on?
Yes.
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 Okay. In that case, we will consider the previous amendment number an editorial mistake and keep this. All right. All right. On House Bill 258, I don't want to take that up today because the chiropractors and the veterinarians are still talking about it. Is that correct, Representative Lakis?
Yes, actually, the chiropractic board is okay with what we were looking at doing, which was just require nationally recognized certification. I heard back from one member of the vet board that they're okay with the plan, but the whole board doesn't meet till the 15th, so we have to hear I want to wait to hear their official
Okay.
response.
And that is not an early bill, so we can postpone it to a later.
And I'll schedule a subcommittee meeting for after that, so we can consider it.
Don't look at me. I was just an alternate on your subcommittee.
Yes.
Oh, that's right. You were there with us for everything, so I guess you adopted us.
Okay. So who else was it?
Point of order, Madam
Yes,
Chair.
Representative Shrew, yes.
On House Bill 193, we voted to accept the amendment. Did we vote OTPA?
Yes, we did. It was 20-0. Does anyone object to consent on House Bill 193? Hope not. That's a perfect consent bill. All right, and is there a fiscal note?
There is, but it's less than 10,000, so I think we're okay.
Yes. The fiscal note is negligible. All right. Yes, please. That was a good one.
Thank you very much, Madam Chair. I'm just going to let everyone know I'm officially calling a subcommittee meeting on HB 436 FN local for Friday morning at 10 a.m. We got to keep that ball rolling. So Friday morning, 10.
Right. And the exec on that bill is recessed until 1 o'clock on the 15th, which is when we have an executive session scheduled on House Bill 655, which is going to be canceled because it doesn't need to be done quite that soon. So we'll get back to the retirement system at 1 o'clock Wednesday.
I'm sorry, Madam Chair, can you please, I was sort of in the middle of walking in, putting stuff down. Can you please explain again? There's going to be a subcommittee hearing on,
A subcommittee working session on House Bill 436 Friday morning in parallel with the 655 work session. We will not have an executive session on Friday afternoon. We will have the executive session on House Bill 436 at 1 o'clock on Wednesday, the 15th. Any other bill we don't get to, we will exec at some later point because it's not up against a deadline. Yes, there is already one subcommittee meeting on House Bill 655. That's been scheduled for a while. That's for Representative Groder's subcommittee.
Yeah.
Representative Simon's subcommittee will be meeting at the same time in a different room on House Bill 436.
When do you expect to exec 655?
Later.
Oh, it's not
It is,
It's not an early
it has
bill.
been changed to not be an early bill, so there's no need to vote on it next week.
thank you.
Goodness.
And if I could get a status on House Bill 250, are we going to look at that again later today, or what is?
We
where-
will get to that later today when Representative Schmidt gets back.
Okay, thank you.
So everybody, I hope everyone is thinking about that. So we're not doing 250. So Representative Grota, you have a motion on House Bill 691, I believe. Is that the one you get or did not get?
I think it's 391.
391. 391.
I do.
think we've gotten that far yet.
I have a lovely amendment here that came as a result of a subcommittee meeting that we had with the sponsor of the bill and the DHHS, which I will pass out. There you go. It is amendment number 152H. And essentially, the
Okay.
the
Before you
amendment.
speak onto it, is there a second?
Oh, I'm sorry.
I'll second.
Okay. Representative Schuett seconds. Continue, Representative Grota.
Thank
sorry.
you. So, and there were, this bill had two parts. The first part was the part that we were all having issues with. The second part changed the reporting from 6 months to a year, which, stayed unchanged as a result of the subcommittee meeting. Everyone's in agreement with part two. And, so the only thing that the amendment does is change part one and merely updates the language to enter into a memorandum of understanding. We no longer use memorandum of agreement as the nomenclature. So we changed it to update into a memorandum of understanding on cooperative regarding data sharing between the Department of Health and Human Services and the Department of Environmental Services, which is something that everybody agreed to, and they do appreciate having the testing going from every 6 months to every year. So I hope that the committee will recommend to adopt the amendment to House Bill 391.
Okay. Thank you. Representative Schuett?
Ditto.
Excellently said. Does anyone else have a comment on the amendment? No, Representative Schuett did. Okay. In that case, the motion is to adopt Amendment 0152 to House Bill 391, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Grota.
Yes.
Representative
Yes.
Schmidt.
He's not here.
Oh, I'm sorry.
He stepped
Representative
out.
Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
Yes.
19 yay, 0 nay.
All right. You have a motion, Representative Grota.
I move ought to pass with amendment on House Bill 391 with amendment 0152H.
Is there a second?
Second.
Okay. All right, Dolan. All right, is there any discussion? Representative Dolan? Anyone else? Okay. In that case, the motion is ought to pass with amendment on House Bill 391, and the clerk can call the roll.
Representative Lakis.
Yeah.
Simon.
Yes.
Representative Lakis. Sorry.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Grota.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
Yes.
19 yea, 0 nay.
All right, the motion passes 19 to 0. Is there any objection to consent? Okay, seeing none, we'll put that one on consent. Representative Grote, you have a motion on House Bill 409.
I do. I'd like to move amendment. Let me just see if I can find it in my pile. Aha, here it is. Amendment 353H. I will pass it out. And so I'd like to move Amendment 353H for House Bill 409.
No, I'll second.
Second by Representative Blackus. Okay. Okay. Representative Grote?
Thank you, Madam Chair. This bill is is a result of a subcommittee that the licensing subcommittee on House Bill 409. The language was to the original language was to strike the sentence, other states' licensing requirements are substantially equivalent or higher to than those of the state. And the recommendation from OPLC, rightly so, was to make sure that the applicant held the current license in that other state that was in good standing. And the definition of good standing is that which is defined by rules, which are the current board rules, which are found in RSA 313A:8, sections 1 and 2. So this was actually discussed with the Cosmetology Barbering Board, and they support the amendment and they support the action of the bill as amended. So I would imagine that we would support this amendment.
Thank you. Representative Blackus?
Ditto, covers it.
Okay. Anyone else have a question or comment? All right, seeing none, the motion is to adopt Amendment 0353H to House Bill 409, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Grote.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
Yes.
19 yeas, 0 nay.
All right, and you have a motion, Representative Grote.
OTPA on House Bill 409 amended with 0353H.
And I'll second.
Okay. Any further discussion? Seeing none, the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Grote.
Yes.
Representative Goley.
Yes.
Representative Schuett.
I was going to make an adverse comment, but since 409 is one of the favorite songs from my youth, I will vote yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. Yes. And the chair.
Yes.
19 yeas, 0 nay.
All right, is there any objection to consent? The motion passes. All right, seeing none, we'll put that one on consent. Representative Schuett, if you'll refrain from making that adverse comment, I will refrain from singing that song at you. Since there, okay. Representative Blackus, you have House Bill 109.
Let me find it here. 119. No, there's,
Sorry?
While he's looking at the reference, I was wondering if we should look for Representative Stewart offering that song in the well.
One never knows, does one?
no, I've got it. Like to make a move to pass with the amendment, and I've got this one right this time, 0214H, and I'm passing them out.
And I'll second that since it's my bill.
Is that the amendment that we talked about during committee? I think we talked about that.
I
correct?
believe that's the one that adds exemptions.
Okay.
For 109?
Yeah.
I'll second the motion.
Okay, thank you.
Okay. What? Sure. Okay.
You can make sure I didn't make a mistake.
Representative Lucas, do you wish to speak to your motion?
I do. This incorporated two amendments. The first one was the one presented by Representative McGuire that was replace some items in the first list that were inadvertently left off. And then it adds the new paragraph at the bottom, and it's just makes it clear that other practices like recreational therapy that do things that could be considered similar to occupational therapy do not need to be licensed under the Occupational Therapy Act. They're licensed separately.
All right, that's excellent. Representative Groder, do you wish to comment?
No, thank you.
Okay. Does anyone else have a comment? My goodness. In that case, the motion is to adopt Amendment 0214H to House Bill 109, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo-Nastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Weber.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Groda.
Yes.
Representative Schmidt. Oh, he's not here. Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. And the chair.
Yes.
19 yea, 0 nay.
All right. Representative Lekis?
I'd like to move to pass with Amendment 0214H on House Bill 109.
I second.
Okay. Any further comments? All right. Representative Lekis? Rhoda? No? Okay. Anyone else? Well, as the prime sponsor, I'd like to thank the subcommittee for fixing what, in retrospect, is now an obvious oversight in the bill. And I appreciate it, and I'm going to be for supporting it. All right, anyone else? In that case, the motion is ought to pass with amendment on House Bill 109, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo-Nastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Aver.
Yes.
Representative Gerhard. Yes. Clerk votes yes. Representative Groda.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susie. Yes. And the chair.
Yes.
19 yea, 0 nay.
The motion passes 19-0. Is there any objection to consent? Seeing none, we'll put that one on consent. All right, and no, we're going to, Representative Schmidt's going to make, and that 250 also. House Bill 266. Did that go to subcommittee?
Yes, I think it went to representative. Didn't it go to your subcommittee?
And it didn't go to ours, mine.
Sounds like a no. All right, let's see.
Does anybody know when we had the hearing on that? I'm sorry. No, we don't have a subcommittee. I have nothing in my.
Okay.
I could move. I mean, if anybody wants to, I could move on a pass on House Bill 266. If anybody wants to
Then I'll
second.
second it.
Okay.
What's-
Okay.
So House Bill 266, and I'm sorry I don't have my bill in front of me, but it does basically codify what should be happening for hybrid and virtual agencies, hybrid meetings. I'm so sorry. Let me start that over. This is what is actually should be happening with hybrid and virtual agency meetings, because we went from a situation where we were having all virtual meetings to those hybrid meetings. There was some discussion and some it was necessary for us to actually write to codify what should be happening in these agency meetings. So that was the purpose of this bill.
Yes,
Maybe-
I'd like to say that it is essentially what the governor imposed as emergency rules during the emergency of COVID. And it worked out fairly well for some meetings. It does meet the requirements of 91A, but it does not authorize any remote or hybrid meetings. It just says if you're going to have one, this is what you have to do. And so that's the intent of the bill. Anyone else have a comment or a question? Representative Schmidt? Okay, good. Thank you. Yes, Representative Dolan.
Since we're no longer under the emergency order from the governor, does that complicate processing of
Yes, it means that that if a board wishes, say, to hold a hybrid hearing on their rules so that it's more convenient for people to call in or witness it without actually having to come to Concord. This says these are the things you have to do to comply with the right to know law.
Thank you.
Anyone else? All right, seeing no one else, the motion is ought to pass on House Bill 266, and the clerk can call the roll.
And can I just ask that the clerk not call me since I was not here for the motion?
You got it. Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santonastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Abear.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Groda.
Yes.
Representative Goley.
Yes.
Representative Schuett.
Yes.
Representative O'Brien.
Yes.
Representative Massimilla. Yes. Representative Davis.
Yes.
Representative Fitzpatrick.
Yes.
Representative Gould.
Yes.
Representative Susi. And the chair.
Yes.
19 yeas, 0 nay.
Okay, the motion passes. Is there any objection to consent? Another one for consent. Okay. Representative Schmidt, you have a motion on CACR 1.
I do, Madam Chair. I move ITL.
Okay, is there a second? Yes. Okay, Schmidt and Bailey. You wish to speak to your motion?
Yes, as everybody should know. So as much as I admire the sponsor, shall I say, the sponsor's enthusiasm for the exciting potential of a lieutenant governor, I don't think that should be a real criterion for our decision as to whether this is a wise idea. And the bottom line really for me is that this system has been in effect for something like 240 years. In that time, to my knowledge, we've had 3 occasions in which the lieutenant governor, certainly in the last 100 years or so, 3 occasions in which a lieutenant governor, had we had one, would have had to step in for the governor. 2 of them were when former governors resigned their office a day or 2 before the end of their term to be able to be sworn in as U.S. senators. Okay, one was Governor Hassan, and the other one was Governor Gregg, I think. I may be wrong about that. The other occasion was when former Governor Hugh Gallen died in office. And the Senate president took over for, I think, about a month. So the system works. The framers put it together to be thrifty, and we still try to be thrifty here, I think, in New Hampshire. And so that's on the one side, but also I think that this plan is very ill-defined in terms of how it would work and what it would cost. What it would cost. The sponsor seems to think it could be done for one person's $150 a year stipendium and so forth. And I think a lieutenant governor would have to have a driver. You're not going to have this person driving all over the state speaking on behalf of the governor, because he or she is going to do something besides sit there and wait for the governor to become incapacitated. And as I said, we have not had that. So the person's going to have a driver / bodyguard just like the governor does. It's a state trooper, okay? But somebody's going to answer the telephone. The lieutenant governor is not going to be answering his or her own telephone. And there are going to be some staff people. So I think this is going to be a lot pricier than what the sponsor thinks. And as I used to say, Ann Landers said, if it ain't broke, don't fix it. Our system is not broken, and we should not do this. So thank you. I'll answer any questions if anybody has one.
Thank you. Representative Bailey?
I believe Representative Schmidt hit it right on the head.
Oh, all right. Thank you. Anyone else? Representative Leckis and then Schuett.
Thank you. Yeah, the prime sponsor is a good friend, and he raised what is potentially a real issue, which could have been, to one side, serious disadvantage in 2019 and 2020. However, you know, having someone who is elected but has nothing to do, I think, is an opportunity for mischief, and I'm willing to accept that risk. And the risk is on both sides, so I don't think we need to do this. Thanks.
Representative Schuett?
Thank you, Madam Chair. Yeah, I think first off that this is a little unrealistic at the cost that was put forward particularly. I will state in answer to Representative Schmidt's comment and on behalf of the women who are in government, the person who did replace Governor Hugh Gallen was Vesta Roy, the Senate president, thus becoming technically the first female governor of New Hampshire. So that worked out to be a good thing.
Okay. Excellent. Representative Aber?
Yes, just one comment. So I respect the sponsor. However, I agree with everybody's comments. And then one last comment is that the Senate president does not make sense for any checks and balances in place. And so maybe in the future, this legislative body might come up with a bill that would support someone else on staff, such as the 5 executive counselors that exist right below the governor and still in the governor's branch. Thank you.
Thank you. Anyone else have a comment? All right. Seeing none, the motion is inexpedient to legislate on CACR 1 by Representative Schmidt, and the clerk can call the roll.
Representative Simon.
Yes.
Representative Lakis.
Yes.
Representative Bailey.
Yes.
Representative Santo-Nastasso.
Yes.
Representative True.
Yes.
Representative Dolan.
Yes.
Representative Aber.
Yes.
Representative Gerhard.
Yes.
Clerk votes yes. Representative Grota.
Yes.
Representative Schmidt.
Yes.
Representative Goley.
Yes.
Representative Shuitt,
Yes.
Representative O'Brien,
Yes.
Representative Massimilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Yes.
Representative Susie, and the chair.
Yes.
20 yeas, 0 nay.
Does anyone have an objection to consent? The motion passed 20-0.
If I'd known you were going to be unanimous, I would have made motions more often.
It's due to your eloquence, Representative Schmidt. And it's also due to good selection of bills to make motions on. All right, we'll put this one on consent also. And, all right, let's go back to House Bill 250. You withdrew your motion, Representative Simon. Do you wish to make it a motion?
I would, Madam Chair. Thank you. I would like to move out to pass on HB 250.
Okay, is there a
Second.
second? Representative Goldie, second. All right. You should speak to your motion.
Yes, after testimony from the New Hampshire Retirement System's representative, the intent of the bill was what I had previously thought, or close to previously what I had thought it was. I feel like if one of our Group 2 employees dies in the line of duty, protecting us, that this is the least that we can do for them. And once again, the fiscal note on it is so small they can barely calculate it. So just seems reasonable and common sense to me.
Representative Goldie, do you wish to speak to you?
Thank you, Madam Chair. Yes, as was said earlier, that there is the option to choose 100% for your surviving spouse. Should you retain retirement age and pass away after you retire? So if you retired and heaven forbid you drop dead 2 days after retirement, your spouse can collect 100%. Currently, the way the law is, if you die in the line of duty, you only get 50%. Now, if that line of duty death could be 1 day before retirement, had you retired and dropped dead a day later, you'd get the 100%. So I think it's a matter of codifying the statutes and making sure you have the ability to get the same amount.
All right, thank you. Does anyone, Representative Blackus?
You know, just, my opposition before was based on confusion over the bill, which luckily we got cleared up. So.
Okay, thank you, Representative Weber, and then Shuitt.
Thank you, Madam Chair. I'll just echo what Representative O'Brien presented, which I thought was rather poignant, particularly if a young first responder dies in the line of duty. His family has set up their whole budget to pay the house payment, to put the kids through college, what have you. And if he or she is income gets reduced by 50%, that upsets that plan for that whole family and perhaps even prevents them from being able to pay off the house, puts them on the street. That's just not right. So I definitely support ought to pass.
Representative Weber?
Thank you, Madam Chair. I support ought to pass also. And during the break, I did speak with Marty from our retirement system in a corrective action for myself alone that I will share with everybody else. I've asked Marty to fill out a graph that I filled out for him that will give us very clear specifics, give us a real life example, and will give us a before and after graph with monies tied to it, with number of people affected. And that's what we use in the aerospace and defense industry. And I think it will work well for our committee as well and prevent what happened a few minutes ago. Thank you.
Okay. Representative True?
Thank you, Madam Chair. I cannot support the ought to pass for a number of reasons. I don't know when this accidental benefit was first created, but I will assume it's been on the books for a while, and that people coming under this provision of the retirement knew what their benefits were. If towns wanted to come up with an accidental death benefit for their employees, I'm sure that there's a way they could come up with a very inexpensive term life policy for their employees if that's something they wanted to pay for. When I read the Constitution, and because I don't have it right in front of me, I will paraphrase, "Thou shalt not downshift." It does not say you can downshift if it's just a little bit. It doesn't say that. It just says thou shalt not downshift. And if the state wants to pay for this, that's certainly another issue. But in this case, this benefit costs money. And who's paying for it? The towns. And that is why I cannot support the bill, because thou shalt not downshift, not even just a little bit. Thank you, Madam Chair.
Okay. Thank you. Anyone else have a comment?
Well,
Yes, Representative Bailey. Yes, please.
Article 28A, mandated programs. The state shall not mandate or assign any new, expanded, or modified programs or responsibilities to any political subdivision in such a way as to necessitate additional local expenditures by the political subdivision, unless such programs or responsibilities are fully funded by the state, or unless some such programs or responsibilities are approved for funding by a vote of the local legislative body of the political subdivision.
Okay. Very good. Representative Gerhardt?
In accordance with 28A, would it be possible to have the political subdivisions vote if they wish to institute such a benefit, or?
No, they do vote to accept the retirement system. It's the modified that makes it an issue.
Follow up.
Follow up.
I'm saying in this particular bill, could they vote to opt in?
No. No, that if the legislator votes to modify the pension system to this extent, the towns will accept it. And they don't get a vote. Anyone else? So that the 50% of pay was adopted by the towns and municipalities when they went into the pension system, but the going to 100% is a 2023 change that is not going to be voted on by the towns. Representative Schmidt.
I'm not sure if it's 100% apropos for this particular situation, but about, 17 years ago or something like that, we had a proposal for, I think, $100,000 payout for Jeff, Representative Goldie.
That comes out of the general fund, Representative Schmidt.
Say what?
The $100,000 death benefit comes out of the general fund.
Exactly. But the thing was that there was a proposal for, I think I was the only one here then, other than Representative Goldie. That's why I'm asking him to pay attention. So because I want you to corroborate or correct me if I'm wrong. There was a proposal for a $100,000 death penalty for first responders, as I recall, right? And we looked at, initially it was going to be an insurance policy of some sort. And they looked at we looked at it, and the cost of the insurance policy vis-a-vis the likelihood that there would be such a death benefit was so much disparate that we decided to do it out of the general fund. And we've had very few of those in the 16 or 17 years since that's happened. They saved a lot of money, in other words, vis-a-vis what we would have paid for an insurance policy. So I'm not sure if that's absolutely germane to this discussion, but I wanted to make sure everybody knew.
Yes, it's not exactly germane because this benefit increase is being charged to the retirement system. And unless we terminally fund it upfront, it will be used to increase the local rates. However small the difference may be. Anyone else? Representative Lekis.
Yeah, Representative True's right. I'm inclined to vote for this, although if bills related, similar to this or having similar effects come in the future, I think a number of us would be more comfortable if they were fully funded by the state and avoid this problem.
Okay, thank you. Other comments? Okay, thank you. The motion is ought to pass by Representative Simon, and the clerk can call the roll.
Representative Simon,
Yes.
Representative Lakis,
Yes.
Representative Bailey,
No.
Representative Santo
No.
Representative True,
No.
Representative Dolan,
Yes.
Representative Abear,
Yes.
Representative Gerhard,
No.
clerk votes yes. Representative Groda,
Yes.
Representative Schmidt,
Yes.
Representative Goley,
Yes.
Representative Schuett,
Yes.
Representative O'Brien,
Yes.
Representative Massmilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Yes.
Representative Susi, and the chair.
No.
15 yay, 5 nay.
Okay, the motion passes. It will be on the regular calendar. Does someone wish to write a minority report? Representative True will write a minority report.
That is due today, Madam Chair.
Indeed. A short one will do. Yes. Okay. All right, so finishing on a high note, House Bill 180. Representative Groda, you have a motion.
I do. I would like to move Amendment 0352, authored by myself and Representative Lekis.
And I will second it.
Okay, if you'd pass the amendment around.
Oh, of course. I'm so sorry. I'm looking
That's
at
okay.
all the copies and I'm keeping them all to myself. There you go.
Well, in this committee, we like to share.
Right.
Okay, Representative Groda?
Yes, so I would like to know how many, I don't know the answer to this, but we've heard this bill at least 3 times in my lifetime, probably more. And the main concern that everyone seems to have, in addition to having an Indigenous Peoples Day, is having it on this particular day, which is actually not really celebrated as Columbus Day. It is actually celebrated as Italian Heritage Day. So this is a strong step in one direction to change the name of Columbus Day as Italian Heritage Day as one of the holidays that is celebrated in New Hampshire. And that's it. We're just changing the name of Columbus Day to Italian Heritage Day.
Thank you. Representative Lekis, you wish to speak to your second?
I do. I did this. I support this for a number of reasons. One is I won't say anything unpleasant about some of the folks that came to testify before this committee, but they made a threat, which is they're going to come back forever until they get it passed. And I figure this takes some ammo away from that effort, which I support. And The other thing that may be a little more comfortable is Representative, I think, Petrigno, who, yeah, he was the one who spoke eloquently against this bill, is on board with this amendment. And while I'm not entirely comfortable with this, going along with this trend of erasing people from history, almost anybody of significance from history has done terrible things, Columbus included. I think this is, I don't feel strongly, but those people irritated me. I'm sorry to say.
Yes, Representative Lekis, we understand you're yielding to your baser nature.
I confess.
Okay. Representative O'Brien.
Thank you, Madam Chair. I am going to support this. I would like to note Representative Gould and several others that did help you with this. I think this is a true olive branch that has been reached. And as an Irishman, I support this. My wife is part Italian. Most of us Irish kids married some form of Italian wife. You can only boil the food so much. So I'll be proud this evening to go home and tell her that I support my Italian friends. Thank you.
All right, thank you. Anyone else? Representative Simon?
Just a quick point of order question. It's not super different necessarily, but it's different enough. I just want to make sure that this is a germane amendment.
If it is not, Representative Grote and I were talking about this, and if we send it in and it is determined to be non-germane, we will hold a public hearing on the amendment and then vote it again. But I think it's close enough to germane, in my opinion. Yes, Representative Gould.
Thank you, Madam Chair. I just want to say that for many of us who are Abenaki, who are Native American, we feel very strongly that what people choose to celebrate is their business. And so I think that Representative Petrigno's testimony, and then especially Representative O'Brien's comments about what the real start of the day was about, and the fact that it started in the North End with a horrible, bigoted hate kind of situation. So I really appreciate all the work everybody's done, and I strongly support this.
All right, thank you, Representative Dolan.
Yes, thank you, Madam Chair. I'm going to be supporting the amendment, but I believe that the bill ought to be ITL.
Okay, thank you. Representative Schmidt?
Thank you, Madam Chair. Well, I've only been to Italy one time, and it was just nipping down in the corner, and wasn't able to visit any of the fabulous cities of Italy. I certainly have seen plenty of pictures of, Milano and many of the other great cities of Italy and so forth. And you only have to, if you can even stand opera at all, and you've heard any of the operas of Verdi, Aida, and so many others. As a singer myself, I've performed the Manzoni Requiem by Verdi and a number of other works of his, and the great Italian sculptors, painters. And when you think that the initial purpose of Columbus Day was to rehabilitate the reputation of Italians at a time when they were under considerable assault in areas of this country. And Columbus was somebody everybody had heard of, even if he'd never been to the American shores. So I think the idea of Italian heritage is something that if you don't know enough about it yet, well, you can start with pizza anyway and spaghetti. You can always make me happy by inviting me for a spaghetti dinner or pizza. So I think this is, as Representative O'Brien said a moment ago, an olive branch in the direction of getting out from underneath the idea of trading Columbus Day for Indigenous Peoples' Day, and it's a step in the right direction, so I'm going to be voting yes. Thank you.
Yes, Representative Gould.
And let me just say that President Biden this year declared both Indigenous Peoples' Day and Columbus Day for that Tuesday in October. And certainly, we all know as Indigenous people or as Abenaki people, we can go to the governor and ask for a proclamation. There's nothing in this action we're taking today that prohibits or goes against all the towns and municipalities that have chosen to celebrate Indigenous Peoples' Day.
Good to know. Anyone else? Representative Simon?
Thank you, Madam Chair. I don't have any particular malice towards the amendment. I'm not sure if I'll support it yet or not. I'm still thinking about it. Some of my concerns are just by moving in the direction of changing Columbus Day to Italian Heritage Day. I guess it opened, like Representative O'Brien said, should we change St. Paddy's Day to Irish Heritage Celebration Day? I didn't think you'd be as excited about that. I also just wonder, obviously I have a great deal of respect for all of the Italian members of the United States of America and the state of New Hampshire, but we are representative of just about every nation on the planet. And if we start naming things after countries' heritage days, I think we open up a whole slew of opportunity for where's my Lebanese Heritage Day and where's my French Heritage Day. So that is so one of the concerns that I have with going in this direction. My other concern to Representative Lakis's comments is I don't think this will actually ameliorate them from coming back again. I think they're looking for something very specific and they're very passionate about it. And I think they'll return even if we do this because they're looking for the Indigenous Peoples' Day to be codified. So I'm not sure that it fixes that problem. And I think it opens us up to potentially other problems as well. So
Representative Gerhardt?
Thank you, Madam Chair. My main concern with this is really just having the government dictate what's a holiday anyway, when really a holiday is a holy day. And I think that's kind of a personal decision. So to go to the people with the guns and say, we want this to be the official holy day, I think is kind of getting into weird territory. But on the federal level, I always tend to end up there, we are up to now 44 paid days for federal employees for all the various holidays. And I think we've kind of gone over, my point being, there's a point, is I just don't want to see New Hampshire end up following the same route where we end up with more paid days than work days.
This, first of all, even for the government, holidays are not necessarily paid days off. And Columbus Day is, in fact, a federal holiday under that name. Yes, follow up.
Follow up. This is actually from a Forbes article, and the quote was, "This makes 44 paid days off for the average federal employee annually, which is nearly 9 full weeks of paid time off each year." So.
Okay, Representative Grote and then Lekis.
I just want people to understand this is not complicated. We are just codifying what we are actually doing. We're not adding any holidays. We're not changing anything other than the name of the day to represent what people are actually doing. They are celebrating their Italian heritage, and we are codifying that by changing the name of the day. That's it.
Okay, Representative Lekis.
Yep, ditto. It doesn't add, nobody gets another day off with this. So.
Okay, Representative True.
Thank you, Madam Chair. I can remember back in my youth listening to Mao Zedong give a speech. And I'm paraphrasing because my Mandarin is really, really rough. But he was saying that for their Cultural Revolution, they had to get rid of the 4 olds. I think it was the old ways, the old customs, the old habits, and the old ideas. And that's why I don't support the amendment and I don't support the bill, because that's what I see this as, a continuation of erasure. Thank you, Madam Chair.
Okay. Anyone else? I'd like to say that I'm opposed to it because I think Columbus accomplished a great deal, and regardless of his personal moral failings, he changed the history of the world, and I think that's worthy of note. So I'm not in support. Anyone else? Okay, we've all spoken our piece. The motion is to adopt Amendment 30352 to House Bill 180 by Representative Grota, and the clerk can call the roll.
Representative Simon,
No.
Representative Lakis,
Yes.
Representative Bailey,
Yes.
Representative Santonastasso,
No.
Representative True,
No.
Representative Dolan,
Yes.
Representative Abear,
Yes.
Representative Gerhard.
No.
Clerk votes no. Representative Grota,
We.
Do you need a translator? Representative Taylor?
Representative Schmidt,
Our former member Judy would appreciate your voting we in his name. So I will say yes.
Representative Goley,
Yes.
Representative Schuett,
On behalf of Italians, C.
Representative O'Brien,
Yes.
Representative Masmilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Uh-huh.
Representative Susi, and the chair.
No.
So 14 yay, 6 nay.
Okay, that motion is adopted. Representative Grota, you have a motion?
I do. I have OTPA motion for House Bill 180 with Amendment 0352H.
And a second? By Representative Gould, okay. Any further discussion, or have we beaten this dead horse? Okay, thank you. In that case, the motion is ought to pass with amendment on House Bill 180, and the clerk can call the roll.
Representative Simon,
No.
Representative Lakis,
Conflicted, but yes.
Representative Bailey,
Yes.
Representative Santonastasso,
No.
Representative True,
No.
Representative Dolan,
No.
Representative Abear,
Yes.
Representative Gerhard.
No.
Clerk votes no. Representative Grota,
Yes.
Representative Schmidt,
Yes.
Representative Goley,
Yes.
Representative Schuett,
C.
Representative O'Brien,
Yes.
Representative Mesmilla, Representative Davis,
Yes.
Representative Fitzpatrick,
Yes.
Representative Gould,
Uh-huh.
Representative Susi, and the chair.
No.
I'm sorry, 1, 2.
Yes.
I got
Yes.
13 to 7.
Just quickly, uh-huh is Abenaki for no. That's where y'all got that from. It's uh-huh.
So
Uh-huh.
you voted yes. Were you voting yes or no, please? We took it as yes. Oh. Okay, fine.
I said it backwards.
Fine, we assumed it was in English, so that's okay. All right, the motion passes 13 to 7, so that will go on the regular calendar. Does anyone care to write a minority report? I hope not. Okay, not seeing any, we'll let the minority go in silence. Okay, anyone else? I think that's the last we have to do. And House Bill 436 will have a subcommittee meeting Friday morning and will be exec next Tuesday, which is, I believe, the 15th. And House Bill 258 will be exec at some point. I believe we have to make it a time known, so I'll put it on the 15th, but we'll push it out from there.
Okay.
Okay. Thank you all very much.
Madam Chair, can you just make sure, I'm over here. Can you just confirm who you're expecting reports from so that we don't leave you high and dry?
Thank you, I appreciate that. All right, House Bill 337 is Representative Schuett. 449 doesn't need one. 571 is split report, Simon and Goley. 341 is Santanastaso with a minority report by Grota. 620 is a split report with Leckus in favor of ITL and Grota in favor of ought to pass with amendment. Goley again, no report. House Bill 193, Leckus. 391 is Grota. 409 is Grota. You're going to prioritize the more important ones. 109 is Leckus. 266 is Grota. CACR1 is Schmidt. 250 is Simon with True writing a minority report. And 180 is Grota. So whichever ones you want to get on the calendar, turn in first. Sometime tonight, please. And thank you all. We'll see you tomorrow for some new bills. Yes.
This evening when I get home, if I get it to you late or in the early hours of the morning, is that acceptable? Would I be in
I hope
time?
so.
Or?
I hope so.
Okay. I will do my best.
Yes.
But I left work to come and I have to leave here to go back to the...
Work is work. Yes. Work takes priority.
I'm thinking about the Pepper Ford. I got right there.
Yes.
Jane, it probably has most of that data.
I have that data. I was taking notes, yeah. Well, that. Yeah, I've got that.
You want to do that now?
You want to bring that up?
Sure. I'll see. Yes, you can sit down if you like it. Yes, Chris.
Sit over there.